So, the noting is
directed for demarcation of the land.
Well, it is the lookout of the central government, because
I don't dispute that. You are directed for demarcation.
So demarcation part is over.
Yes.
So infrastructural development under national conservation policy. So it is to be abided by, my lord. So compliance affidavit is not received.
My lord, so far as the prayer in the writ petition is concerned, it is already been complied with. And I have instruction that they have already taken up the construction work. Madam, give me only 1 week time so that I will file the recent developments in the matter. But the order of the writ petition by the Honorable Court has already been complied with.
No. You file because under national conservation policy.
Prayer in the writ petition,
No, to ensure
Will you argue in chorus?
Sorry.
Will you argue in chorus side by side?
Miles.
Yes. So according to you, the order has not been complied with.
Complied with.
According to you, whether the order has been complied with or not.
My lord.
Yes or no?
No.
All right. Which part of the order has not been complied?
My lord, the paragraph to ensure protection of the temple. So page number 7, my lord.
Yes.
Having regard to submissions, we dispose of the writ petition the direction to the collector and Tahsildar, so and so, OP number 4 and 5 respected, take up the task of joint demarcation as per the aforesaid letter issued by the superintending archaeologist, OP number 3, and ensure protection of the Ananteswar temple located so and so. So the
so which part of the order has been
secondary part, ensure protection of the temple. So under national conservation policy, temple is notified in 2014. So after that, I have filed my lord 2 to 3 writ petition to have some infrastructural development, because every day, my lord, it is the crown of the temple is in ruined state and no boundary, no the policy. There are so many criteria there. So how to protect the monument? So after this order, Lordship's order, after this order, so according to them, we are taking steps. But practically, as far as complaints report, my lord, to be received, so Lordship will be, my lord, to be
but direction was to whom?
OP number 3, my lord, superintending archaeologist. Because it is notified by the DG, Director General, and Ministry.
So far as state is concerned, they have.
Demarcation part is over.
No, the direction is to whom?
Direction OP number 3, superintending archaeologist, my lord, Odisha Circle.
Direction is to superintendent.
Sorry, my lord. OP number 2.
OP number 2. What the OP number 2 is required?
My lord, under the policy, they will he
was required to demarcate.
Joint demarcation in presence of the state functionaries. So demarcation part is over. So other parts, my lord, the boundary and the restoration of the monument, if renovation is required.
Restoration.
My lord.
Who will do restoration?
My lord, the central government. Superintending.
There is no direction to central government.
Ensure protection.
So that is not to the central government.
OP number 3 was directed. Collector was directed.
Yes.
So, my lord, in the interest of the monument, so if they are taking steps, I have no information from neither from the petitioner side nor from their side. So at least, my lord, they may appraise the lordships, the steps taken by them, so that I will appraise the petitioners. Thereafter, lordship may close the proceeding.
Representing whom?
I am appealing for opposite partner 1 and 2. Contempt.
Let's come this side. Yes.
But in this case, the prayer has been in the petition to opposite partner 4 and 5 to demarcate the plot and construction of the monument 1. Now the demarcation part is already over. So far the prayer of the writ petition is concerned. And kindly.
You are representing Union of India.
My lord.
All right. So
now,
that was not your part.
No, I have instruction. No, that is not. This is joint venture with the presence of all the opposite party. Demarcation has been made. That is the prayer of the writ petition. Now that part of the contempt doesn't lie over that matter. Now, so far as my learned senior is saying about the taking steps taken care of by the Archaeological Society, I have instruction, specific instruction that we have already raised the construct boundary walls, and I have also photographs. If my lord give me 3 days or 7 days time, I can.
We are giving you 4 weeks time.
My lord.
All right. In the meanwhile, whatever can be done,
My-
ask your officers to do
My lord,
and then file an affidavit.
deeply obliged.
All
Yes,
right.
my lord.
Lots of.
Obliged to.
As requested on behalf of the Archaeological Survey of India.
My lord,
Archaeological Survey of India. List this matter on 4 weeks. Stop. The court expects that the Archaeological Survey of India shall in the meanwhile take all necessary steps which can be taken to ensure protection of Anantaswara temple at
At Landura Bhagwanpur.
Sura Bhagwanpur,
Functioning under OP number 3.
keeping in
Located.
mind the spirit of the order dated 8/12/2020, passed in WPC number 22563 of 2020. Correct.
Well,
Item number 2.
obliged to.
Your lordships. Here, my lord, the appellant challenges the impugned order under Annexure 3, my lord, passed by the Honorable Single Bench, dismissing the writ petition on the ground of applicability of res judicata. So far, the appellant's land is concerned, my lord. The appellant belongs to scheduled tribe community, my lord. And another matter came up before this honorable court, and this honorable court passed this order, admitted the writ petition, called for the take. Your lordships may kindly pay
Just a minute, just a minute.
my lord.
Yes. So what is wrong?
The respondent number 2 appreciated the entire evidence and settled principle of law with regard to restoration of caste land in favor of the scheduled tribe person. That is
So, but
at
that everything was decided already.
my lord. Under Annexure 1, my lord. Annexure 1, the original authority, OST-LR, that is whether the principle of res judicata is applicable so far as the appellant's land belonging to scheduled tribe is concerned, my lord.
So
That
which
is your
order-
lordship
which
may
order
kindly.
was- Which order was challenged before the learned single judge?
The appellate court's order under Annexure 2, my lord. The respondent number 1 did not take into consideration the fact that, my lord, so far as the scheduled tribe land is
Order was under challenge before the learned single judge.
Annexure 2, my lord. That
Annexure
is
to which part? 11/10/2006?
8/8/2007, my lord.
Just,
8/8/2007.
yes,
I am placing the order, my lord.
just a minute. So there was an order passed on 36/2006.
My lord.
Earlier, there was an order passed on 36/2006
My lord.
by OSD-LR.
But that is in my favor, my lord. That order is in my favor.
That an order was passed.
My lord.
Against that order, an appeal was preferred
By the respondent number 3, my lord.
by the respondent number 3.
My lord.
You were party to that. In the appeal, you were implicated party.
Yes, my lord. In the appeal, I was implicated party.
So that appeal against that order was decided.
Decided by the honorable single judge, my lord.
Honorable single, not by honorable single judge, by the appellate of by the single judge.
Appellate authority.
By the appellate, that order was decided by
There
the,
was
My-
one order,
my lord,
there was one order against
My-
which an appeal was preferred,
my lord,
in which you were also a party.
my lord,
That appeal was disposed of.
my lord.
Now you also filed an appeal.
No, my lord.
No.
I did not file any appeal, my lord. That is my
You
submission.
filed the second appeal.
RMC case was filed by the present appellant. That was allowed. That being agreed with
What is
annexation,
RMC? No.
my lord,
What is RMC? Revenue miscellaneous-
regulation miscase, my lord. That is regulation miscase, my lord. If the non, there is regulation to 1956, my lord, matter relating to regulation to 1956. 3(1), section 3(1) of regulation to 1956, my lord, states that, my lord, whoever the land belonging to scheduled tribe persons without any permission by the non-scheduled tribe is illegal void, my lord. And section 3(a) states about the unauthorized possession, my lord. So far as the present respondent number 3 is concerned, my lord, he was in unauthorized possession of the appellant's father's land, my lord. Whether res judicata will be applicable or not, that has been vividly appreciated by the learned respondent number 2, my lord. That is at page, my lord, 28. My lord, kindly see page 28, my lord. There was an issue, my lord, to that respect.
What was the dispute?
Dispute with regard to 60 decimals of land purchased by the respondent number 3 from the father of the present appellant, my lord. This is the dispute.
This was the dispute.
My lord.
And this RMC was filed?
RMC was filed by the present appellant for restoration of that land measuring 60 decimals, my lord,
All right.
which was in unauthorized occupation of the respondent number 3, my lord.
All right.
And issue number 5,
Just a minute.
my
RMC number?
RMC number, my lord, 82 of 2003,
You had filed.
my lord. Under section 3A,
This section 3A.
my lord. Original.
And RMC number 12 of 1967.
As many as 6 cases were initiated, but those were clubbed up together and decided in the same proceeding, my lord.
They were RMC 12 of 1967.
My lord.
This was filed by whom?
Filed by RMC, that was filed by Buduram Oram, Buduram, one of the brothers of the present appellant. That was dropped, my lord.
So that was dropped and that related to the same transaction.
Yes, my lord.
That related to same transaction. Therefore, the appellate authority reached a conclusion that since the disputes were already decided in RMC number 12 of 1967, of 67, this RMT 8267 was barred by res judicata. This is the finding of the appellate authority.
My lord, this is against the settled principle of law as laid down in the case of Amarendra Pratap Singh. My lord, I am handing over. The- Page 11, my lord. Law of limitation is not applicable.
This is not law.
Locus standi is also not a matter so far as the land belonging to scheduled tribe is concerned.
Yes, where is that?
Page 11, my lord. My place, my lord. Page 11, in the bottom. Page is in the bottom. Right.
And land was sold by whom?
Land was sold by the appellant's father, my lord, in a plain paper. There is no registered sale deed. They also did not produce the registered sale deed, my lord.
Where is that at? One second.
Act, my lord.
If press for this, the concept of locus standi loses its significance.
It loses its significance and state is the custodian of the ST property, my lord. Anybody can file, my lord, to protect the land of the ST property.
No period of limitation is.
No period of limitation is
By
required,
para 3A.
my lord. Earlier proceeding was initiated under section 3(1) and the instant proceeding was initiated under 3A of regulation to 1956, my lord.
The law is very clear. Transfer is completely forward. Transfer is completely. Yes, 1 week, 4 weeks.
Item number 3.
Item 3, I'm a petitioner, my lord. The annexure 1, page 13, paragraph 5 of the ordering portion, that not complied, my lord. Reading the portion, consider the submission made and without expressing an opinion on the merit of the case, this court will grant liberty to the petitioner to file a fresh representation before the object partner 3 to register post with a period of 2 weeks from today. That has not complied, my lord.
They will comply. Page,
Page 13, my lord. Page 13, paragraph number 5, the ordering portion.
page 13 or page 12?
Page 12.
12. I think paragraph 5, my lord. Paragraph 5, my lord. 12, 13, my lord.
Yes.
Yes, I'll find out because we are still listed for the first time. Try to find out.
This order is of
2022 millions. I think must have been completed because there was a direction to dispose of the representation only. I'll find out. Because,
2 weeks time is allowed for an AGA to seek instructions and file affidavit as regards compliance of this court's order dated 3/2/2022, passed in WPC number 10749 of 2021.
Item number 4.
May I please? My lord, the disciplinary proceeding has been post admittedly, my lord, because normally, my lord, this honorable court held that it has not been concluded within the time stipulated by the tribunal. And the tribunal stipulated 6 months' time. That 7/11/2014 order was passed to conclude the departmental proceeding within 6 months' time. It was received by us on 3/5/2014. And we, after concluding the, we should have within 6 months, my lord, 3/5, it comes to 3/11. So actually, my lord, the fact is the fact, my lord, on 11/11/2014, we, because he was a class 2 officer, so we have to give it to gazetted officer, we have to give it to OPSC for concurrence, the punishment. So the matter was referred to the OPSC on 11/11/2014, and on 24/12/14, the OPSC concurred. So my lord,
No, what is the delay in the
we have, my lord, committed 1 month delay. 1 month, 438 days delay. No, my lord, on the merit of the delay, there is delay. I was addressing on merit, my lord, on merit. Delay, my lord, so if my lord will not be
Inordinate delay.
if I will not be able to convince on merit, then naturally,
Being
my
a
lord,
part of that other bench, we condoned, we were lenient up to 90 days.
no, my lord,
States-
condoning of
states action.
130 days.
So beyond that, we did not permit, subject to my lords.
My lords were condoning up to 130 days.
So we have referred to some Supreme Court judgments also.
No.
Say
Here,
that even Bherulal case and other cases.
here, my
So
lord,
inordinate days delay without plausible explanation
no,
from the
29
side of the state.
I leave it to my lords. But on merit, my lord, this is the fact. Actually, because the matter was.
no, but what is the law that if there is a direction by the court to conclude a proceeding within particular time, and if the proceeding is not concluded within that time,
No,
the proceeding will become what?
because my lord, the direction is, it will be deemed to be.
Oh, deemed to have been caused. Then
So my lord, that
no
we.
merit.
That's on facts, my lord, I stated that.
No merit. ये number
459 of
the order. By an order dated 29/7/2022. A disciplinary proceeding was initiated against the respondent in August 2012. For short. As the respondent had approached the Orissa Administrative Tribunal in the matter of departmental proceeding by filing OA number 3648 bracketed C of 2012, which came to be disposed of by an order dated 11/4/2014. With the following direction. Full stop. Next, it is an admitted fact following direction, page 14. 14 of the brief.
In 15 there will be direction.
No, page 14. Page 14.
14.
They have quoted.
No, page 14.
That is page 14.
14. Page 2 of the order.
It is an admitted fact that the departmental proceeding could not be concluded within the period stipulated in the order passed by the Orissa Administrative Tribunal. Stop. In the departmental proceeding, however, after the lapse of the time prescribed in the order of the tribunal, an order of punishment was passed on
13/1/2015. That is actually wrongly 13/11.
13/1/2015.
No.
Stop. Assailing the said order of punishment, the respondent preferred a writ petition before this court, giving rise to WPC bracketed OAC number 200 of 2015. Stop. It is worthwhile mentioning that there was no application filed seeking extension of time for conclusion of the departmental proceeding as directed in the order dated, as directed by the tribunal in the order dated 11/4/2014. Stop. Learned single judge, after having taken into account all the facts and circumstances, including the order passed by the tribunal, set aside the said order of punishment dated 13/1/2015 by an order dated 29/7/2022, passed in WPC OAC number 2. Which has been put to challenge by the state of Odisha in the present intra-court appeal. Stop. Next. This appeal is barred by limitation in as much as there is delay of 468 days in referring the appeal. Stop. We have referring the appeal. Accordingly, an application has been filed wide IA number 459 of 2024 seeking condonation of delay. Stop. This is the only reason disclosed in the application seeking condonation of only reason given in the application given in IA number 459 of 2024 for condonation of delay, paragraph 4. Stop. We are not at all satisfied with the explanation put forth by the estate as noted above for condoning delay of 468 days. Stop. IA number so and so is accordingly dismissed. Stop. Consequently, the writ appeal also stands dismissed.
My lord, only one correction. My lord, selling the order, the petitioner approached tribunal, which the matter on abolition of the tribunal got transferred to this honor.
Oh,
That I.
My friend is appearing for the respondent.
selling that order, he had approached the tribunal.
Not tribunal.
From whom?
Selling the order of punishment dated
13/1/2015.
13/1/2015. The respondent had approached the Odisha Administrative Tribunal, giving rise to, what is the number?
That is OA 200C of 2015.
Giving rise to OA
200C
00C
of 2015.
2015, which came to be transferred to this court upon abolition of the tribunal.
And renumbered as WP.
Tribunal, which matter stood renumbered in this court as WPC OAC number 200 of 2015. Those facts I have just mentioned.
Item number 5, my lord. I seek an adjournment for 2 weeks to obtain instruction with the present status of the proceeding, my lord. So, my lord,
Status of?
the proceeding, that is, my lord, is a relevant fact in this case, my lord. So, my lord, may grant me 2 weeks time.
As requested on behalf of the applicant. This matter on 2 weeks.
Item number 6.
Obliged, ma'am.
Necessary.
This matter, to your lordship settles.
Is
in
this system
estate.
convenient for the second row lawyers?
Well,
Is this whether the desks put there, that is convenient? Do you find any change, Mr. Rao, in the courtroom?
No, it's convenient.
No, Mr. Rao, he's asking about, his lordship is asking about second row, the tables are put. Is it convenient for the sitting arrangement of lawyers?
Yes, please.
That should be arranged in almost all the courses, more convenient for the second row.
Yes, It should be there in all courts. And first row only for the arguing corporate. The second row should be there where one can prepare to go to the first. So it should be there in every court. Since you already asked, it was given. Let us see. Within our mind very long time, but there was no opportunity to say.
Yes, sir. In this matter, my lord, yesterday, the matter was there before the Supreme Court. I am grateful, my lord, your lordships have been able to point out a mistake in the prayer. I'm just filing a formal amendment petition because there I wanted to challenge the annexer 5. That is the order dated 25/2/24, modifying the earlier order dated 7/2. So inadvertently, that sentence was missing in the prayer. Just I have filed a petition for amendment and correction.
We can take up your matter tomorrow. You file it in the registry.
Yes.
Let this be numbered and then, all right.
But if it is not inconvenient to my friend and your lordships, can it be on Friday or Monday?
It can be on Friday.
Right, because tomorrow I am absent.
Leave this matter on Friday.
Item number 7.
May I please, my lord? My lord, my lord, I am through online mode with your
Yes,
lordship.
please. Yes.
My lord, here I have challenged the order of the Honorable Single Judge directing a person who is not of the college to remain principal in charge till, my lord, formation of common cadre, which has been directed by the Honorable Judge in another case, that throughout the state a common cadre of the, my lord, lecturers should be formed so that there will be a permanent principal instead of a principal in charge. Now, what has happened, my lord? Here I challenged the order at Annexure 10, page 41 in the writ petition on the ground that the person who has been kept principal in charge is much junior to me so far as the college is concerned. Now, that writ petition along with 2 other writ petitions were taken, and during the course of hearing, this Annexure 20, my lord, page 70, was brought to the notice of the Honorable Court, wherein a person who is working in a different college has been kept principal or in charge of the college where I am working, and I am the senior most. Now, this order is taken out of, and an order is passed that he will remain principal in charge. This order, my lord, was never, we are never given any opportunity to challenge. In any event, he is much junior to the present appellant, so he can't be kept principal in charge. Now, the order, your lordship will see, the order of the Honorable Single Judge, my claim has not at all been considered even. Your lordship will kindly turn to page 75. Page 75, your lordship. Paragraph 2, paragraph 3, though the order is referred to as 11.
Which annexure? All right, got it.
My, that is Annexure 21, your lordship.
Annexure 21.
My, and
Page
relevant page is
72.
page.
Annexure 21 is page 72.
My lord, your lordship will kindly peruse page 75.
75 is part of the order of this court. See, yes.
My,
Got it.
paragraph 3,
Yes.
government produces an order indicating that one Himanshu Shekhar Dwivedi, reader in English of Sukinda College of Sukinda, has been permitted to discharge the duties of principal in charge cum secretary of Vyasanagar Autonomous College, Jaspur, in addition to his own assignment. Now, this order is being accepted by the Honorable Single Judge, and without even considering my claim, though I am the senior most in Vyasanagar College. This Himanshu Shekhar is of, he is of Sukinda College. He doesn't belong to this college at all. Now, the government produces an order that is at page 70, your lordship. This order of dated 6/3/2024 was produced on 11/3, and this has been accepted without even dealing with my claim that I am the senior most, so I should remain principal in charge as per the circular issued by the government. So therefore, I am before your lordship. I will be retiring in June, my lord. I do not know whether, my lord, by June the common cadre will be formed or not. I have a right to continue in view of their own guidelines. It is not that I am claiming on the basis of anything else. Now, a third person who from a different college is kept principal in charge, that order is produced. Even the Honorable Single Judge did not consider whether that will be a valid one or not, and whether my claim is justified or not. My claim has not been dealt with. Your Lordship may kindly peruse the order.
So you are in April.
My Lord.
Is there any post of professor in charge?
Principal in charge, Your Lordship.
Principal in charge. Is there any post?
The senior most person is kept principal in charge, and
That is just a temporary.
I'm not disputing that. But I will have an expectation because of this guideline issued by them. And they do that.
We can take up your matter in June.
But true it is. But that is why my grievance is, and here Your Lordship, a third case. But during the course of hearing, they produce an order which is nowhere.
These are, and a teacher should not be much interested in administrative work.
But there is one
He should be a teacher should have more interest in teaching, not in.
I am doing that, my lord. There is no blemish. I am doing that. One thing I beg to point out, Your Lordship.
Most of the topmost professors do not accept the post of vice chancellor. Do you know?
I'll just point out one thing. There are three matters where I am appearing to the respondent.
You appear to be an outstanding teacher. Why should you become professor in charge unnecessarily?
My lord, Your Lordship will kindly consider.
You have such a bright career, and at the back end of career, why should you go for this?
My lord, one of the writ appeal pending for this noble court, the honorable division bench, where my friend Mr. Samir Das is appearing for the appellant and I am for the respondent. Your Lordship has been pleased to fix the date, I guess, for next week. And because of my bereavement, I am not able to attend before Your Lordship physically in court.
We do not find any merit. And such matters.
Kindly consider. This is a completely third case and my case has not been considered. Your Lordship may kindly peruse page 77.
Even if, why we are very rather anxious. Why should you? We are surprised that you are so much interested in administrative work.
But it is not that way. What I humbly beg to submit, I challenge someone else from my college being kept as principal in charge.
Yes,
now,
sir.
The government makes out a third case. It is not their case. Well, they had kept.
Why are you fighting? That is the basic question.
Because of the right that flows from their.
What right? Therefore, we put this question. Is there any post of principal in charge?
I would humbly say yes, because of the circular at page 48, Annex 13.
Very difficult.
They have said that guidelines for fixation of seniority of teachers.
All right, let us see. We will decide your case. Let us see the order. We will decide.
The order of the Honorable Single Judge, Your Lordship.
Yes.
Yes, my lord. Your Lordship may kindly see. May I place it, my lord, in extenso from page 75. The dealing is in paragraph 5, page 77.
Yes.
Having heard the Land Counsel for the parties and considering the instruction provided by the Land's additional government advocate, all these three writ petitions are disposed of by allowing Sri Himanshu Shekhar Dwivedi to continue as principal in charge of VN Autonomous College, Jaspur, till common cadre of lecturers of non-government aided colleges is duly formed and further action is taken in terms of order passed by this court in the case of Premalata Raut versus State of Odisha and others. The principal in charge, who has now been appointed to act as principal in charge of VNS Autonomous College, Jaspur, is also directed.
There is absolutely nothing wrong in it.
This much I can point out. They are acting contrary to their own guideline, which is prevalent, and Your Lordship will find in 99% of the cases, the senior most lecturer is kept as principal in charge. That is what they are. That is because of this. And Your Lordship, one matter is pending for this, Your Lordship, in writ appeal as to whether I should be the principal in charge or the appellant.
Whether the principal in charge gets more salary.
My lord, it is not. It is an honor because of the seniority.
Very good.
It's an honor.
No, sir. This is not an honor.
And it is contrary to their own decision. That Your Lordship.
Appellant has put to challenge an order dated 12/3/2023 asked by a learned single judge of this court in WPC number 5193. Your case was, which was your case? 5193?
5193, Your Lordship.
5193 of 2024. And other analogous matters whereby the writ applications aim to be disposed of with the following direction. Paragraph 5. Stop. When senior counsel appearing on behalf of the appellant has vehemently argued that the appellant is senior to which respondent? Himanshu Sekhar is which respondent?
Himanshu Sekhar was not a party to the writ petition. But order was produced and that was accepted. Because on the very day it was accepted, there was no occasion to make him a party.
He is senior to respondent number 4.
He is not at all belonging to that college. He is belonging
Mr. Misra. Mr. Misra.
Man.
Himanshu is senior to Dilip Kumar Mahanti.
But
Respondent number 4.
he is senior to Dilip Kumar Mahanti, but he is junior to the present appellant. And he doesn't belong to that college. He belongs to Sukinda College. That is at page Your Lordship will find.
His appointment was made. All
Very day the judgment was delivered when order was passed. The order was produced. There was no occasion to make him a party. He is not a party to the writ petition. But on the day it was produced, the order was accepted.
So, but who had appointed him? When was he appointed principal?
He was appointed under Annex 20, page 70, order dated 6/3/2024. And that was produced on 11/3 and was accepted before the Honorable Single Judge. He is in Sukinda College. He has been kept in charge, additional in charge of our college, VN College.
He argued that the petitioner being, that the appellant being the senior most teacher in VN Autonomous College, Jajpur, ought to have been appointed, designated as the principal in charge of the college. Stop. Next. He, however, fairly admits that the appellant is going to retire in June this year. Stop. Firstly, we do not find any such illegality in the impugned order passed by the learned single judge requiring one Himanshu Sekhar Dwivedi to continue as principal in charge till a common court cadre of the lecturers of non-government aided colleges was duly formed. Secondly, the very fact that the appellant is going to attain the age of superannuation within 2 months, we are not inclined to entertain any challenge to the said impugned order. This appeal is accordingly dismissed.
Okay.
Item number 8.
My lord, matter into admission nursing course, my lord. Management got a batch of case, my lord, judgment reserved. It will come after disposal of the
All right.
I beg pardon, my lord. We are for the Indian Nursing Council. The copy has not been served upon us.
No, but it has become infracture, Mr. Counsel.
my lord, judgment reserved.
All right. This matter after 4
Disposal
weeks.
1482 2024
all right.
and batch.
Item number 9.
My lord, may I please your lordships? Here, my lord, the petitioners being the Sarapanchas of 3 Gram Panchayats, my lord, they have filed this writ petition PIL for a direction to the opposite parties to initiate a land acquisition proceeding and pay adequate compensation to the recorded tenants of 5 villages on which land, my lord, so many pillars have already been fixed, my lord, without initiating any land acquisition proceeding, my lord.
We may impose exemplary cost in such matter. Because you are espousing cause of individual persons whose lands have been acquired.
Because they have no
Exemplary.
means, my lord.
Exemplary. What is this?
ST persons, my lord.
Huh?
The lands on which lands, my lord, railway pillars are being fixed, my lord. They have no means to come to.
Very good.
court, my lord.
If they have no means, we will provide them means.
Oblige, my lord.
We may provide them means. You ask them, you ask any one of them to approach the legal service authority. We are there. The whole system is there for them. Ask them to go. Do you have the address of the state legal service authority?
No, my lord.
No. You don't have any knowledge about
Yes,
legal
yes, my
service,
lord. I have.
state legal service authority.
Yes, my lord. I have.
Ask them.
My lord. Then I am withdrawing.
Ask them. They'll take up the matter with the district administration, the land acquisition officer, the High Court. They can go to Supreme Court.
They are all
Don't
sarpanch.
say that.
They are all sarpanch.
They are all sarpanchs, my lord. Three.
Don't do this.
They have the means to agitate their grievance, ventilate their grievance before the competent.
They have ventilated their grievance before the opposite party number 3 under annex of 4 million.
Counsel for the petitioner, after some argument, seeks permission to withdraw this writ application. This application is accordingly dismissed. We make it clear that the persons individually affected by the acquisition of land shall be at liberty to approach appropriate forum for the redressal of their grievances. Yes.
Item number 10.
May I please, your lordship? My lord, this writ petition is PIL in nature. My lord, the private opposite party number 4 and 5 encroach upon the government land which is reserved for common utility purpose. The petitioners are
Yes.
villagers.
Follow that order.
My lord, I have represented the authority.
No representation.
They consider, my lord.
There is an order passed by this court.
My lord, my lord.
Right.
My lord.
Yesterday. 130.
Item 11.
Oblige, your lordship.
May I please, my lord? So this matter was before lordship on last Saturday on 6th of April blocks. Because the petitioner here challenges two notifications of the central government under section 168A blocks of the CGST Act.
You are assisting him. Come this way.
This matter is identical with that of one other matter at item number 66. Because all these matters your lordship directed to list it today mirrors. And my lords have directed my friend Mr.
All the
Pari.
matters have been listed.
So two have been listed only. One, this matter, and other is item 66. Other matters are also there.
How many matters are there?
WPC 6964.
Lordship, 3 other matters are there. I have already given a list of those matters.
What is the
Lordship,
issue?
item 66. There is another matter tagged that is WPC 6964 of 2024.
Please wait. We'll come back. We'll revert back to you. Yes.
That's in all the writ applications, my lords. Notifications dated 5/7/22 and 31/3/2023, my lords. These two notifications are issued by the Government of India under purport under 168A of the CGST Act. Because thereby extending the outer time limit to complete adjudication proceeding under section 739 minutes.
Oh,
your lordship knows 168A contempt force majeure. So in absence of such a situation being there in July 22
so
and
those
also
matters, how many matters are there?
from our office about 5 to 6 matters, and other matters also your lordship have also directed to be listed today also.
Do you have any idea? Who is for the other side? They can give us clear picture.
Yes, they can give us. Your lordship kindly see the order dated 6/4/24. There is specific request to Mr. Pari to remain present today. My lords have directed in the order itself.
That was a request.
Yes. Your lordship have requested Mr. Pari Deputy Solicitor General to remain present today.
That was just
No,
a request.
his name is not reflected.
No, reflected, my lords.
Reflected.
Yes, yes.
In the cause, no, in the cause list.
The
The cause list, yes, your lordship is correct. Probably that is the reason he might not
the
have.
name of Mr. So party
And also Tushar Kanta Sakpati, he is appealing for the council, my lord.
and Mr. Tushar Kant
Sakpati.
Satpathy be mentioned in the daily cause list. Daily or weekly, what do you put? First, in the cause list. In the cause list. First off, list this matter. Tomorrow, it will come again. Just for that purpose.
My lord, yes, yes.
Just for the purpose as to how many cases are there.
Along with
And-
these three, my lords, I have given.
Please tell him that this is the purpose for which the matter has been adjourned. He should give all the list of all the cases.
Will inform, my lords.
Mr. Who is appearing for CGST? Commissioner?
For union of.
No, for commissioner, who is appearing?
Lordship,
All
Mr. Satpathy
are against central government.
Yes, Mr. Satpathy is appearing.
State of Orissa.
Mr. Satpathy.
He is for CGST.
Yes, Your Lordship. On last occasion, his associate said that he is not present today, so he'll be returning tomorrow.
Let us, then we can take up on Thursday.
Thursday, my lord.
Thursday.
Just inform.
Lordship, I'm appearing for the petitioner in
Thursday
WPC.
is a holiday.
6964.
Please, yes,
Thursday.
you are appearing in?
Lordship, WPC 6964 of 2024, that is tagged with item 66. The issue is the same, Lordships.
All right.
Thursday is a holiday, your lordship.
Thursday is holiday. You will come on Friday?
Friday.
Friday. Mr. Party has come. Oh, no problem. Your name has not been printed, therefore.
But I sought for instruction, I could not receive.
No, the instruction is one thing. You please give us the list of cases involving similar issue.
Fine.
All right.
Yes.
So by Friday.
Fine.
On Friday, we'll fix a date for hearing of all such cases.
Increment to continue, my lords.
Interim order shall continue. Yes, 66 will be taken up, Mr. Counsel.
Obliged, Lordship.
You taken up.
Item number, sir.
The 66 order, same order you passed in 6 minutes. 11 and 66.
11 is.
Fine.
Any problem?
No. Obliged.
Item number 12.
That's,
Yeah.
I am in a public interest litigation where agricultural land of 696 acres were there and a sealing proceeding was initiated against the ex-chief minister of this state. And it was found that only 200 acres were surplus and 474 acres of land worth about 5,000 crores was excluded from the purview of the sealing proceeding simply on the ground that the lands are situated in urban area. It's true it is, if it is urban area, it's a homestead land, then only to the extent of 3 acres exemption is available. But how 475 acres were excluded is not known. And glaringly, I was looking at the newspapers and found and started inquiring. On inquiry, I found that the draft statement filed by the landowner saying that these are my lands access, which is mandatory, that is missing from the record. Returns filed by the landowner is missing, draft statement prepared by the Tahsildar is missing, everything is missing. And I came to know that this matter has drawn the attention of the assembly, and a committee who are to inquire into the matters were inquiring into the matter, and the revenue authorities appeared before them and said that, yes, that's a mistake, we should not have done it, and this will move a higher authorities, but nothing is being done. But in this process, what has happened, the excess land of about 500 acres, which could have been given to the common general public, is deprived. It's only because of this high-handed actions of the Tahsildar and revenue authorities, only because the landowner is a very influential man, this could be possible. That was one of the oldest cases of Balangir, and that was disposed of like this perfunctorily. I have issued a notice under the PIL rules. Even then, the revenue authorities did not work up to file an appropriate appeal, revision, or to reconstitute the file, nothing. Therefore, I was constrained to approach this honorable court. If Lordship permit, I will serve extra copies and let them take instructions on this matter. My Lord, this is a very serious issue.
No, but when was that done?
This was only 2019.
What?
This dropping the proceedings. The proceeding was initiated as early as in the year 1974. That was kept pending. And
Yeah,
now
your notice is of 20th February this year.
20th. Yes.
And when did you file this?
I filed it on 28th
Of?
March. 28th. I filed it on 28th March.
You should have waited for some time then.
Let them take instructions, but I don't have an issue. I don't say that immediately it should be decided. So long it waited.
No, but what can be done now?
Well, it's written.
What is the position of the land today?
Land is being enjoyed by the landowners.
Many are lying there.
They are influential people. They use it. They alienate it. They do anything.
They must have. This is what we are so saying. We apprehend. Those lands must have been alienated in the meanwhile. Maybe illegally.
That's why I have also filed an interim application.
Large numbers also.
Some lands were alienated and they may further alienate. Therefore, I have filed an application for a restraint order that no third-party interest should be created in the meantime.
But Mr. Senior guy, I must tell you that I'm not surprised. This is the national phenomena.
That's right. That's right. Very few people rise to that case.
Only by the privilege.
I don't think the beneficiaries have been benefited by the provisions of the Sealing Act.
Very correct. Very few people will come.
This and Bhudan.
Sealing
Act and Bhudan. In fact, I had taken up one of the proceedings under the Bhudan Act. I made all the attempts to ensure where are those lands lying which were donated. Thousands of acres could not be identified. They were just for the purpose of evading the rigors of sealing.
Quite correct. So, really, it's a very shocking thing. But what can be done?
Let us examine it.
Right.
Then we will ask them to.
Yes.
The legal aspect and everything. Then let us see.
Was it 7 to 11?
The
Property of Rajendra Narayan Singh there.
Ex-priest.
We will see. It will come after 2 weeks. In the meanwhile, we shall also examine the legal aspects and other aspects. And if required, we will ask them. All right.
Yes, if you will permit me, I can also give them extra copies so that they can also be of service.
Please wait. I don't think whether the Land Reforms Act provisions have been duly implemented anywhere in the.
If your lordship permit, in Odisha it is implemented much better, accepting some few privilege. Because Nandini Satpathy was there, he came from a different background. He leftist oriented. In a very short, immediately she implemented the Land Ceiling Act, and all big landlords, not the biggest one like the present one, their lands were taken. Those who were obstructed, they were remanded to custody, and lands were taken, and large number of scheduled caste, scheduled tribe people are distributed in Odisha. After probably in Punjab, I was at that time a student, I came to know that in Orissa it was implemented to a greatest extent, accepting the few big landlords and some intelligent people to avoid selling, they used to have partition.
This is
There are very few in Orissa.
Not only that, many of them donated their lands for
Yes.
Bhudan.
Yes. But those are very few in Orissa because of that period, because your lordship knows large number of the area is the tribal. So they don't possess that
Let us see.
intelligent brain to overcome all these things.
Let's this matter on 3 weeks further. When the court will consider as to whether the notices are required to the estate or not. Why do we issue to the estate or not? Yes.
Item number 13.
My lordship.
In item 13, the lordship has directed yesterday one of the officer will remain present. The lordship has directed for VC, but he has,
VC, all right. No,
he has come in persons.
tell us what can be done.
This year, sir, we issued the notification much earlier. Also, we took the registration of the schools, the students much earlier. And in the first phase of lottery, we have allotted almost 17,000, which was highest, even combined together of 3 lottery last year. And we are going to have a second lottery. If possible, we can also go have a third lottery. So the registration of students and the school registration concurrently went off. That's why in different dates, the registration of schools increased day by day. So we have allotted 17,000 and we will allot equal number in the second lottery.
No, but as I'm able to recollect, according to the petitioner, new schools have come up.
Yes, ma'am.
And those schools have not taken into account while
During the first round of admission, those were not.
As per the notification 2021, only the schools, those have received the COR or certificate of registration are only eligible to participate in the.
All right. So there may be a situation where subsequent to that cutoff date, some of these schools might have got COR.
Will allow.
So, and tomorrow is the, tomorrow
is the second round.
Second round of registrations. Will allow the students school registration as well.
Please do
so that it will go concurrently, the student registration and also the school registration. And it will help the students.
My lord, if school registration also happens concurrently, then again the number of schools will keep on increasing. The school registration has to stop at one cutoff date.
You think that the two processes, like the moment some school has what do you call COR,
yes,
certificate of registration. The moment a school has certificate of registration, that is there in your system, so that may reflect the number of vacancy for admission.
Yes, this year we are having a unified portal where the COR portal and the RT portal will be synced.
That can be done easily. That can be helpful for the future also. So presently, what can be done? What can be done? Just a minute. According to you, what should be done? Madam.
My lordship, presently the issue is that the number of schools went on increasing. First round of admission is over. So another round of admission may be created, which is already there in the notification that there should be 3 rounds of admission.
That is what he is saying.
Another third round of admission. My lord, then the next is why some of the schools are not appearing. Last year, I have a screenshot of 4,442 schools. This year, there are 3,300 schools. So what happened to those 1,000 schools which are not appearing?
Maybe they have lost their,
My lordship, if that
they
could
might
be,
have lost their.
if that could be given.
That they will look into that.
And my lord, there was one more issue regarding the entry classes. Like the same school which was available last year and is available this year, but the number of seats have reduced. If that also can be looked into.
Why the number of seats are reducing?
Sir, as the school registration is, the number of schools registered is less than last year. So the number of students allotted also will be reduced.
No, school-wise. Suppose in one
Same
school, the number was 25.
So no, the
And
same.
the next year it is less than 25.
It is
less.
It is same.
That
If
is,
a
there is
specific,
a
specific,
discrepancy.
proposal comes or any intimation comes to us, we will inquire and we will.
That's a matter of calculation.
That's Arun point.
So we can dispose it off.
My lordship, kindly keep it there because till the admission gets over. If it is disposed of, then we
Third
cannot.
round? When will you have the third round?
We'll, after the second round, sir, we'll have the one overlook of the students applied. Then we'll have a third round. Keeping in view the number of students. Sir.
It is good that you are taking interest and you appear to be a very sensitive person. So we hope that you'll do something. Pursuant to this court's order dated yesterday, the who are you? What is your designation?
Director Elementary and Nodal Officer RT.
Director Elementary Education, Odisha, come Nodal Officer.
RT. Right to education.
Right to education. Mr.
Jyotiranjan Mishra.
Mr. Jyotiranjan Mishra is present in court. First off, responding to the grievance raised in the present writ application in the nature of public interest litigation, Mr. Mishra has submitted that third round of, what do you call, council?
Online lottery.
Third round of
Student registration.
And also third round of admission.
third round of exercise shall be under. We are not using this expression lottery.
Admission.
Third round of
Student admission.
exercise shall be undertaken to ensure admission of students against 25% quota in private schools,
Unaided.
unaided private schools under the Right to Information Act.
Education.
Sorry, Right to Education Act. So stop. We do appreciate the assurance given by Mr. Mishra to this court. So stop. We expect that he shall make all endeavor. It has been submitted by MS Adisa Mohanty, Learned Counsel, that after an exercise for admission begins in such unaided private schools, some new private schools get COR, Certificate of Registration, which are not included by the state agencies for grant of admission. So stop. Next. We do appreciate the assurance given by Mr. Mishra that he shall take all possible steps to ensure that even such schools are also included in the exercise and exercise in the third round. And in future, steps shall be taken to integrate new schools in the new schools getting OCR for the purpose of admission of children under the said scheme. That's all. Let's this matter on. When will you have the third round?
We'll have almost in the month of May, sir.
Month of May.
Latter part of.
So we can take up the matter in May,
Man.
say 16th of May.
May to
16th of May.
15th of May.
Last
Man.
By 16th of May, you also come out. You may also come out with a policy, a system as to how we are going to integrate new schools for this purpose. That will serve your PIL.
My
Purpose
lord,
of your
in
PIL.
case any discrepancy or any other issue arise in between, then who do we
He is
approach?
the best person.
To the director.
Mr. Mishra can solve anything.
To the
One thing,
nodal.
madam,
Let us see.
directed that the new schools, madam, kindly add subject to verification because you have certain verifications to make.
And that is those who get OCR.
Ma'am.
That is the verification. Yes. So if a school does not have OCR, that is not to be taken into account. So new school means the schools having OCR not having been included. That's the idea. That is clear from the order also.
My lord.
Oblige.
The personal attendance of so and so stands dispensed with for the present.
Oblige.
Item number 14.
Please, your lordship. Signature of PL matter, my lord. It's a petitioner giving representations as Annex 2 and 3. And according to that, the authority 4 and 5 initiated some process. Letter has been given since 2018 for a fake caste certificate, issuance of fake caste certificate. And my limited grievance is that Annex 2 and 3 may be disposed of.
Sorry. Sorry, will not do that. Whose caste certificate is fake?
I have mentioned, my lord. And also in that annexure also given.
Show us the annexure.
Annexure at page 41, my lord. Verification of caste status of Kishore Chandra Tarai, son of such and such. And in several letters, my lord, of RDC, my lord.
Which annexure?
Annexure 2, my lord.
Which caste certificate is fake?
SC schedule caste.
Which you must have produced some certificate which is fake.
My lord.
Where is that certificate?
That is been submitted before that OP 4 and 5, my lord.
That could have been submitted before the court also.
Next time.
Which caste certificate is fake? According to you, certain caste certificates are fake.
Fake.
How do you know?
Because we, the petitioner, we are the scheduled caste persons.
So you must have seen the caste certificate. You must have seen the fake caste certificates.
Next date.
Well, where is the question of next date? These are the matters in which cost should be imposed.
Pardon me.
Unnecessary file.
Because we are the aggrieved persons.
Huh?
Aggrieved persons, we are deprived of.
You may be aggrieved, but you will have to show. Someone asks you to file a PIL, you are filing PIL. As you wish. How much? the present rate application in the nature of public interest litigation has been filed. Calling upon the opposite parties to. What is this disposal of representation?
Well, Annex 2 and
This is the way.
after giving representation, they have issued the letter, but that has not been complied. That is also in that.
They should impose costs in such matters. No, you will not withdraw.
I am permitted to withdraw my land.
You may not. We are not asking you.
No, I am.
But we are very sorry about the state of affairs.
I'll file a better petition.
Filing a representation, then you are getting some letter, and the very foundation is missing.
Pardon.
Before filing PIL, you have to do some kind of research also.
Pardon. Next time I will.
Learn counsel for the petitioner after some argument seeks permission to withdraw this rate application in the nature of public interest litigation. The application is dismissed and withdrawn. Just, we are coming with you. Admitted at the bar that this court's order violation of which has been alleged in this application has been complied with the passing of orders by passing of an order by the learned by whom?
Special land officer, special land acquisition officer.
Special land
Acquisition officer, Lower Indra Irrigation Project. Lower Indra Irrigation Project, Karyar.
Lower
Indra Irrigation Project.
Indra Irrigation Project.
Karyar.
Karyar.
OP2.
Bracketed OP2. This application stands disposed of accordingly. So it goes without saying that in case the petitioner feels aggrieved by the decision of so and so OP number 2, the petitioner shall be at liberty to question the correctness of the same before appropriate forum under appropriate provision of law.
Highly objective.
Stop.
Item number 18.
Item number 18, that has not yet been complied. Rather, opposite party 1, the order that is under Annex 1 of my contract petition, direction was if any deduction has been made from the running bills of the contractors, that is to be refunded. That was the order. But the opposite party 1 has under flag A have filed one affidavit by suppressing the material facts, that is Annex C1. They want to incorporate a clause in the DTCN.
So the direction is at page 12.
Page 12, my lord, page 12.
Paragraph 3.
Page 12, my lord.
Page 12, paragraph 3 is the order.
My lord. It is last 5 lines. It is made clear that any deduction made from the running bills of the contractors or any payments made to the contractors in pursuance of the notification dated 24/12/2012
Sir, refunded. In fact, lords, we have refunded him 1,40,000 after deducting the amount due to him, lords. That is our lords decision. If he is agreed with that, he can approach the lords.
No.
We have direct.
Yes. Commission. Maybe.
What has been done and what has not been done?
Yes, my lord. 24,11,000 has been deducted from the running bills of the contractors. A batch of cases were disposed of. A common order was passed. A common order in a batch of cases. In some of the cases, They have complied, they have refunded the money, but in our case, money has not been refunded. Thereafter, what they did, Annex C1 of flag A of their affidavit.
What is the violation? Just see the last sentence of the order.
My lord,
It is made clear that any deduction made from the bills of the contractor
my lord,
or any payment made to the contractors in pursuance of the notification so and so shall be refunded.
shall be refunded.
Plus adjusted.
No, that is not applicable adjusted, that is refunded. But that word is refunded, that is applicable to us. In other cases, that may be adjusted, but in our case, that is to be refunded. 24,11,000 by virtue of one circular that was quashed. After quashed, that is to be refunded. This is the case. What happened thereafter? They have filed one affidavit on 23/2024 after issuance of notice. They have taken a stand, Annex C/1. Annex C/1, one office memorandum they issued dated 7/6/21. That was challenged before this honorable court by one contractor, and the same was quashed.
Mister, we are not concerned with that. We are concerned with this order which was passed in 2018.
My lord.
So if there is any subsequent development, and if that subsequent development is in violation of this order, you can show that.
Yes, that I am showing, my lord.
What?
Thereafter, on 7/6/21, Wash Department issued a circular. They say they want to introduce some clauses in the DTCN with retrospective effect from 7/7/12 to 18/11/19. That circular under Annex C/1 was challenged before this honorable court. That was quashed. So that 7/6/21.
That was caused by in a different proceeding.
No, my lord, in a commerce proceeding, my lord. Well, they have taken a stand. 7/6/21.
You are saying that order was passed in 2021.
21.
This order is of 2018.
My lord, they have annexed, my lord, documents, my lord. My lord, they have annexed that document. They saying by virtue of the said office memorandum, we have deducted.
So they have deducted because of the said office memorandum. Where is the question of violation of this order? If you are aggrieved, you can challenge. We will give you that liberty.
My lord.
All right. It is stated by Mr. By AGA representing the contemners that this court's order dated 18/6/2018 has been complied with, and the amount which the petitioner has been found entitled to has been refunded in terms of
not refunded. My instruction is not refunded.
Yes, I paid.
Any document to show?
Yes, annex.
No, not refunded.
Paragraph 10 of the affidavit filed by the contemner secretary. If you also kindly look at 24 lakhs was due to be paid to
Any
him.
document they have to show that amount has been transferred to my account.
Let him say.
My lord.
24 lakhs are due to be was deducted from his account, but 22 lakhs and odd was recoverable. Accordingly, that deducting the amount, 1 lakhs 23,000 has been refunded to him.
So whether this 1 lakh has been refunded?
No,
to you or
not refunded till date. Last night I have taken instruction.
After adjustment, they have not refunded the
No,
balance.
only document they have adjusted, but physically not refunded.
Yes, also may say if not refunded, it shall be paid to him within 7 days.
Either you or he. Either your client or his client. Action shall be taken against.
Well, also take it up 2 o'clock.
Last night,
whether the amount has been paid or
Take
not.
up tomorrow. We will take up the matter tomorrow.
Yes,
my lord. My lord, last night instruction. My lord.
All right, his instruction is also recent. Your instruction is last night.
Yes. They have filed one more line.
When was that filed?
Which, my lord? What?
When was his reply filed?
One reply has not been taken into account. Opposite party one has filed one show cause. That is not on record. That is with me, but that is not on record. opposite bed 5 has filed one.
20th of March.
No,
I filed this opposite
just
bid.
I'm showing my lord. Opposite
20th
bed
of
5,
March,
they have,
I filed
they
the
have sick, they have sick.
He filed on 20th of March. You have not filed any reply.
My lord, this is the document.
Just a minute, this matter tomorrow.
Item 19.
So Samantra, you take instruction on para 10.
Yes.
After adjustment, whether you have refunded the
That
balance.
exactly was.
Item 19.
May I please, Your Lordship? The matter was yesterday and it was also adjourned to today, man.
The order has been complied with, Lord, sir, and it has been communicated to him. The order was disposed of, Lord, 9/9/2022. I've got the order of the, Lord, sir, collector. It was disposed of on, Lord, sir, 9/9/2022.
Let them saw the copy so that.
They get it.
I'm giving you a copy, Lord.
It is
And
stated
liberty may
by
be given if I agree.
learned counsel appearing of learned AGA that AGA representing the contenders that the court's order dated 23/6/2022 has been complied with the comma with the passing of an order dated 9/9/2022 by Tahsildar.
Lord, collector Khurda, Lord.
By the collector Khurda. A copy of the said order dated 9/9/2022 has been served upon learned counsel for the petitioner in the court. From this, the order, this court's order having been complied with, comma, this application stands disposed of, but with the liberty to the petitioner to question the correctness of said order dated 9/9/2022 if he feels aggrieved by the same.
Item number 20.
May I please, Your Lordship? Your
Item
Lordship.
number 20, just a minute. Lord. Here the challenging the order, we had approached the Honorable Supreme Court, Lords, and the SLP has now been dismissed, Lords. So now we have to comply, Your Lordship.
Now, the petition is aged about 80 years. The differential salary has to be paid, man. But till date, the order has not been complied.
2 weeks time, Your Lordship, we will pay him.
As requested on behalf
And they have already on the last occasion, they have taken a 6 weeks time, but not yet complied.
When was the SLP dismissed?
I have enclosed the last, the petition, Your Lordship, can see page 22, annexer 5 of the content petition.
Yes, ask him to be present. Who is the officer?
Lord, sir, DEO, District Education Officer, Khurda, Lord.
The court's order dated 1/8/2022 and 24/7/2023 passed in WPC number 8670 of 2013 and CONTC number 350 of 2023 has admittedly not been complied with.
So in the direction to all the authorities, madam. Your Lordship, kindly see. Let the commissioner be present, madam.
When the matter was taken up on 27/2/2023, 24, the court was assured that the aforesaid orders shall be complied with within 6 weeks. Stop. Till date, there is no compliance of either of the orders. Stop. It has been stated at the bar that an SLP was preferred against this court's order dated 1/8/2022, which has since been dismissed by the Supreme Court. Stop. Next, in such view of the matter, we are of the considered view that the defiance of this court's order by the contemners prima facie appears to be willful, deliberate. Stop. A case is made out for initiation of contempt proceeding against them. So stop this matter on 15th. This matter on 15th. When? Who are the officers?
Open number 1, man.
Who was
In fact, it has to be completed by the DEO, Milords, because it's a differential salary. The district education officer has to pay it, Milords.
What is his name?
Milords, his name is
Biswanath Tare. Yes.
Let the district, what is the name?
Biswanath Tare.
Opposite party number?
3.
3, Milords.
Let opposite party number 3, Viswanath, so and so, be personally present in court on 15/5/2024. So, he will be required to show cause as to why he should not be proceeded against and adequately punished for willful disobedience of this court's orders. Stop. He will also be required to furnish to this court the names of all such officers who had held the post of district education officer of this district, who were required to carry out the orders, aforesaid orders passed by this court. So stop. Needless to say that he will be required to disclose the period during which he has been occupying the position of district education officer and the time and the date when he learnt about passing of this court's orders as noted above. Yes. Yes. 15 for 2 p.m. Date fixed, sir. Ah. Huh? 15th. Oh, all right. 15th days. 15th.
Item 21.
That's item 21, Milords, the disposal of 28A application. Yesterday, Lordship, similar matters. You have please to grant me 2 weeks time, Milords. Let it 2 weeks, Milords. All these matters will come next week. We will do that, Milords.
2 weeks.
My friend was also there.
Contemptuous list is matter on 2 weeks.
Item 22.
My lords, order 27 to 2024.
My lord, on behalf of the opposite party, my lord, I have received an instruction that order of this honorable court has been complied with. Has been complied with, ma'am. And we'll file a compliance affidavit within 2 weeks, ma'am.
Yes, let him.
This is this is instruction.
See, if he's satisfied, then we can dispose it off.
May I pray this matter come tomorrow so that I can a copy may be served.
Just give him, tell him. Otherwise, if the order has been complied with, then complied with.
Yes,
no
ma'am.
requirement.
I'll verify that
But
tomorrow.
he should be satisfied.
Nice.
Yes.
Item 24.
Item 24, my lord. The petitioner has alleged the non-compliance of the order dated 24th January 2023, my lord. The direction was para 9, my lord, order dated.
Yes.
It will open to this to Sri Subhranshu party to bring the same notice of the collector in appeals. The order passed on 5th August 2022, passed in OA number 84.
Where is the order?
Order is at, my lord, page 7. I have quoted the order.
Quoted.
Yes, my lord.
You are not annexed.
Annexed also there.
No, you are not annexed.
Order is at page 21, my lord. Operating part. Page 24, operating part, para 9.
Which part of the order has been violated?
Para 9, my lord.
There is nothing in para 9.
Any other issue concerning the MGQ for period during which the sand chariot was not able to be operated will also be considered by the collector in accordance with law. Pursuant to this direction, my lord, I have approached the collector by annexure 1 at page 13, my lord. My grievance petitions. The same has been registered as miscase number 63 of 2022.
That is still pending.
Now they have passed order. The government has transferred the mines mines
So
department.
where is contempt? Where is the disobedience?
They have not disposed of my representation till yet, my lord.
This is the representation. It will be open to Subra Sankar Padi. You are the person.
My lord, me.
To bring to the notice collector in the appeal,
My lord.
the order so and so, by very same, and any other issue concerning MGQ for the readers will also considered by the collector. Collector has considered.
Not considered till yet, my lord.
No demand has been made as yet, my lord.
For a refund of the MGQ, my lord.
How can there is no direction for refund, my lord? If any, my lord, he says that he could not operate if for that non-operational period, if demand is made, not will consider that. But till that, no demand has been made raised either by the collector or by the mines department, my lord.
Pursuant to his direction, I have approached the collector. Collector has not decided the matter till yet, my lord.
So you are saying some order has been passed. And where is the direction for the collector to decide the appeal?
Direction is at my lord. At para 7, my lord.
So para 7 has not been implemented.
No, para 7 is different, my lord. That appeal has to be filed by some other persons where he is a respondent. So appeal has got nothing to do
All
with
the
this.
three matters, my lord. All the three matters are tracked together, and I have filed my grievance petition. The same has been registered as miscase number
So
63
how
of.
paragraph 7 is concerns you? Paragraph 7 is not about you. Paragraph 9 is about you, and there is no positive direction as to in what time the net has to be disposed of.
My lord, my target.
After having gone through this court's order dated 24/1/2023, we are of the 23 and the averments made in the present contempt application. We are of the view that no case of violation of this court's order is made out. So, the order to the extent it relates to the petitioner was only to the effect that it was open for the petitioner to bring to the notice of the collector in the appeals, an order passed on 5/8/2022 in OA number 84/2021/EZ by National Green Tribunal, Eastern Zone Bench, Kolkata. On careful reading of this order, we find that no positive order was passed which has passed to the extent it relates to the petitioner which has been violated. Stop. We do not find merit in this number. There is nothing. There is no case is made out for initiation of contempt proceeding. Stop. This application stands disposed of.
Item number 25.
Lord, para 9 is the continuance of para 7, my lord. So para 7 direction will be.
Para 7 was not, the appeal was not filed by you.
Yes, my lord. Filed by me. That annexure 1.
No. Paragraph 7 was filed by you. The appeal was filed by you.
The petitioner in WPC number so and so are permitted to file an appeal against the order dated 30th September 2020 and its earliest appeal number 21 of 2021 before the collector.
This is your petition. That is your writ petition which is being referred to.
Yes, my lord. 3 writ petitions are. My lord, kindly turn to page 21.
Just a minute.
Page 21, WPC 24045 of 2021, second writ petition filed by me, my lord. And second one is also filed by me.
Paragraph 2 of the order at page 22.
Yes, why the appeal has not been disposed of?
No. Appeal has not been filed by him. He is the successful Soirat source owner.
But he had also filed writ petition.
He had filed a writ petition. In his writ petition, the annexure 9, paragraph 9 order was passed.
Para 7. Writ petitioner of 37019 of 2021
They filed an appeal before the collector.
He is Sanjeev Parida,
Yes.
not Subhranshu
No.
Shekhar Padi.
Challenging
What is your
it-
name?
Subhranshu Shekhar Padi.
Subhranshu Shekhar Padi.
So, whether you filed any appeal? Did you file any appeal in terms of the order?
Yes, my lord, that is annexure 1, my lord. Persons to direction given by this, liberty given by this honorable court.
But para 7 is confined to 37019 of 2021.
তিনিটা କରି ସାଙ୍ଗରେ dispose of ହେଲା.
Have you seen this para 7? Have you seen this para 7?
My
This is confined to WPC number 37019 of 2021.
My lord.
So
That was not
petitioner
your-
therein is not Subhranshu Shekhar Padi, rather he is Sanjeev Parida and others.
My lord.
So petitioners therein, they are given liberty to file appeal in para 7.
So far as
Whereas you were not there in para 7. Claiming under para 9, you have come up in contempt. So no contempt is made out.
so far as
Qua-
para 9, my lord.
You are petitioners. You have filed 2 petitions.
We will have to convince you that the order for filing an appeal was not in relation to your client. It was in relation to someone else. All right. So paragraph 7 doesn't apply in your case. But that was in case of someone else. Your is covered by only paragraph 9. And there is nothing in paragraph 9.
Paragraph 9, my lord. Any other issue concerning the MGQ for the period
Yes,
during
that
which
liberty was given to you. That's
Well,
all. That
pursuant to
liberty,
this direction I have applied, but
Collector shall, in accordance with law.
if we find
So
it
he
very
has not yet.
we find it very difficult to convince you. We attempted. We did our best.
Advisory jurisdiction we have applied for.
Please
Item 25.
be satisfied that we are not against you. We again tried to see the order. All right.
I am only trying to say that it is the.
Then we
conduct-
have not been able to understand.
Man.
Then you can blame us.
No, man. I am obliged.
Order has been complied with.
25 complied with. 25.
25.
It is admitted position that this court's order violation of which has been alleged in the present contempt application has been complied with. This application stands disposed of accordingly.
Item 26.
Right,
On
item
behalf
26.
of Mr. B.K. Naik, my lord, your lordship may kindly see order dated 3/4/2024.
So whether order has been complied
Yes,
with? or
yes, lords. Order has been complied with. He is online, lords. He has passed the order, lords. I filed the compliance affidavit yesterday. Your lordship, paragraph 6, that is humbly submitted that the pension sanction order will be issued by this office after computation of verification of the service records of the petitioner along with all relevant documents and shall be forwarded to the office of the accountant general for release of the revised pension will be taken 7 days time. Lords. Accordingly, your lordship, he has paid for 7 days time. We will comply with the order, but your lordship may keep this pending and I will come up before lordship with that affidavit. Lords.
Let a copy of the affidavit be solved.
I will give it.
who has joined? Who has directed?
Yes, lords. Your lordship has directed the district education officer Puri to join. Lords.
Court's ordered it 3/4/2024. The district education officer Puri has joined the court proceedings online. First off, it has been informed by Mr. L. Samant Rayal and additional government advocate that this court's order has been complied with to the extent that necessary sanction orders have been issued for payment of pensionary benefits, and the sanction has been communicated to the office of the accountant general for issuance of necessary authority slip. First off, the process of authorizing payment may take about a week. First off, place this matter on 2 weeks. It is hoped that in the meanwhile, this court's order dated 22/11/2023 shall be fully complied with, in which the court shall have no other option but to proceed against the contemners. First off, however, considering the subsequent conduct of the contemner district education officer, his attendance on the next date stands dispensed with. Yes, this will matter on 2 weeks.
Item 27.
27 months, I filed the complaint affidavit. On 28th, we have complied the lordship's order.
Complied with.
Well, liberty may be granted to
Liberty
challenge the
to-
order
It
for
goes
approval.
without saying that the petitioners shall have liberty to question the correctness of the order passed in compliance of this court's order in the writ proceeding before appropriate forum in accordance with law.
Both the cases.
Both the cases accepted.
Item 28.
In this case, the labor commissioner has instructed all the collectors of the district, but there were to give promotion in line with the order passed by the local pension of promotion of the. But so because now the post of this commissioner labor is vacant since long, I could not get the concrete information. I tried to get it from the collectors concerned, may grant me some more time because we are directed to give promotion.
My lord, kindly look at page 37. The direction is in 2/4. Page 37, my lord, it has been directed, we direct the labor commissioner to upgrade the gradation list following the procedure. Page 37. To upgrade the gradation list following the procedure within a period of 4 months from the date when the petitioner will produce a copy of this order. Then the other direction was, it is needless to say that if the vacancies are available, the zone of consideration shall be created on the basis of the gradation, and the persons in the zone of consideration shall be considered for promotion in accordance with the prevailing rules with expedition. And the petitioners, all the petitioners, there are 5 contempt petition, my lord. They have submitted the certified copy of the order passed by this honorable. More than the period stipulated has already gone. Now my learned friend is telling that he has intimated the collector to do that. The direction was to the labor commission, and he has admittedly not done it within the time stipulated.
So who has disobeyed the order?
The labor commissioner, my lord.
Labor commissioner is the post.
My lord, I have named him in.
What is his name?
Yes.
What is his name?
My lord, Amrit Ruturas and another.
So when was he a labor commissioner? When the order was passed?
Earlier, there is another person who was continuing in that office. He has been implicated as contempt number 2. The lordship may kindly say, N. Tirumala Naik. At the time the order was submitted, this N. Tirumala Naik was functioning as labor commissioner. Thereafter, he was relieved, and the present incumbent has taken over. That is why I have implicated 2.
He is saying that that post is vacant.
My lord, by the time the notice went, the present contemptor was very much there in the office.
He fled away.
Yes.
All right. Let so cause be filed by opposite party number
1 and 2, my lord.
1 and 2, explaining as to why contempt proceeding be not initiated against them for deliberate disobedience of this court's order dated 29/8/2023, passed in WPC number 8659 of 2023. Stop. It appears to be an admitted fact that the said order has so far not been implemented. Stop. After considering the so-called reply, their so-called replies, the court will consider passing appropriate orders as regards orders for initiation of contempt proceeding against them. Stop. It will be open, however, for the authorities to ensure compliance of the said order in the meanwhile. Stop. List this matter on 2 weeks. How many? One or how many cases?
Four, my total 5 cases.
List this matter on 2 weeks of collector order.
They pay some more time.
4 weeks.
Yeah, again.
All right.
Madam. Separate orders will be passed in
Separate orders.
Orders item number 29.
Mr. Samantara, please.
Yes, ma'am.
Now we are getting cases
No, ma'am.
where we can impose punishment.
Right, ma'am. Because of the vacancy of the post work could not be done, I'll see that it's done by the either commissioner himself, ma'am. I will see that it's called down.
And item 29 will be taken up with along with WA 432 of 22. In that batch.
Which batch?
Item 29 is ordered.
29 is to be taken up with?
With WA 432 of 22. Balabhadra Naik, work charge case.
Work charge के साथ fixed to 18.4. Fixed to 18.4. List this appeal on so and so.
What about delay? Delay of 533 days.
And there is delay.
No, if my lord, the case, Balabhadra Naik case is within delay, no limitation. Once my lord decides that case, then these cases with delay, my lord may be able to persuade my lord to impose cost and the same order to be passed.
But 533 days delay.
My lord, I will produce my lord 700 days delay with cost. There is order. So first, we'll see if my lord decide.
No, but this matter cannot be, those matters are for admission or what?
Yes, ma'am.
But this matter cannot be listed along with that.
The notice has not been issued.
My lord, what I was saying,
Notice,
yesterday, also some matters were that it's going to that batch because, my lord, the first matter once my lord decides, then the other matters will automatically, if my lord, if it goes in our favor, so if at all it goes in our favor, then our line of argument before this honorable court will be different. Because on limited, my lord, so I have shown, my lord, remember, on limitation ground, all these job contract matters were also dismissed. Now we have got to stay from onwards. On limitation only, it was dismissed. So that's why I was saying.
All right, we will take up the matter later. This matter
I'll-
after 4 weeks.
Item number 30.
Hello. But in item number 30, the noting is that steps for limitation not taken. But in my calculation, there is no delay, my lord. Because the impugned order was passed under Annexure 4 on 12/4/2023. And the appeal was presented on 12/5/2023 on the 30th day. But the stamp recorder calculated that the appeal was presented on 15/3. That's why they have pointed out that 3 days delay.
You have not filed any IA
No, my lord. I have-
explaining this.
No, my lord. I
Stamp
may
reporter
permit-
has shown 3 days delay.
Yes, my lord.
So you should have explained.
You could have said
My lord, I will file within. a
either
week.
file affidavit or IA, whatever.
Yes, my lord. I will file.
As requested on behalf of the appellant, list this matter on 1 week.
Item 31.
Other defects to be removed with. There are other defects.
Let
I will
other
remove.
defects be removed in the meanwhile.
Okay.
Let the defects be removed in the meanwhile.
Now, so kindly see page 18.
31.
Only direction for consideration, my lord. Writ appeal ought not to have been preferred, my lord. I will take a decision in accordance with the honorable single judge decision. Page 18, ma'am.
What is there?
There is only direction for to consider. So there is no question of any filing of any writ appeal. It could not have been agreed by that against that order.
No, but we could not find the order.
Page 18, madam. 18 of the writ appeal.
22 is the page where order reflects. 3/3/2022.
No, no.
This is 1002 of 2023.
No, no.
Page 20.
Madam, may kindly see page of the writ appeal, page 23.
By the impugned order passed by the learned single judge. So this intra-court appeal has been preferred against an order dated 3/3/2022 passed by a learned single judge of this court dated learned single judge of this court in WPC number 5259 of 2022 by the said order. The learned single judge has disposed of the writ petition requiring the opposite part, requiring the appellants to examine the claim of the respondent for regularization and take a decision accordingly, keeping in view the Supreme Court's decision in case of Uma Devi, in case of State of Karnataka versus Uma Devi, and reported in 2006, volume 9, SCC 1, and State of Karnataka and others versus ML Keshri and others, reported in 2010, volume 11. OLR bracketed SC 982. What is the citation? Equivalent citation SCC ka dekho. Holy good. So we do not find any reason to interfere with such order, which is in the nature of direction to the appellant / state of Odisha, appellant / state respondents to consider the case of the respondent for regularization in terms of the law laid down by Supreme Court. The delay so and so. It is worthwhile mentioning that there is delay of 430 days.
Not 8 days.
408 days in preferring the appeal. We do not find any justifiable reason to condone the delay. This appeal stands dismissed accordingly.
And I have there is no DVP and
This appeal and IS also
2582.
dismissed accordingly. Yes.
Item 32.
May I please? Page 20, the impugned order, my lord. This is regarding that promotion during pendency of departmental proceeding in criminal case.
Joseph Barik.
Yes, it is also covered by my lord's judgment.
We have also
The two judge,
following Joseph Barik and other.
my lord's judgment, also two judgments, my lord have passed in that, in this case, notice it to go, madam. No one-
Notice. Notice.
What is the
Limitation.
de-
Yes, my lord, that is the
delay?
limitation.
Only notice in.
Only on limitation.
They are not filled up.
That.
Days of delay.
Because only that, what are the problem?
You have not filled
Yes,
up.
what was the problem like that computation period from that COVID period, so we could not fill up that.
Is for notice on point of limitation.
Item 33.
In 33, that is Sartapada case. In similar cases, your lordship has issued notice also that there is a delay. In this case, there is a delay.
We were reminding this. We were reminding this matter
Because
learned
no one,
single judge.
yes, no one has appeared, so your lordship on last occasion issued notice. In other matters, your lordship has reminded those where they have respondents have appeared. As in this case, this is coming for the first time. Your lordship issued notice.
So we are required to issue notice.
My lord, that I am praying.
In the absence of the other side, we can dismiss it, but we cannot.
Yes,
ask
that
any
I
other
am
one.
saying.
Issue notice.
On the question of limitation.
Limitation.
35 same.
34.
35 also correct.
That will be called.
Item 34.
Item 34, this can be disposed of even in absence of the opposite party, that in Bindusagar, in light of Bindusagar. So it will not go against them, it will go against us.
Rehabilitation assistance.
Rehabilitation assistance scheme, it can be disposed of. In terms of that, my lord's order is that I can give it just now. I am giving that order.
Item 35.
My lord, sir. Yes, sir.
Yesterday also.
Sit down.
Delay is condoned and in terms of Bindusagar.
Yes, my lord, sir.
We have followed the others.
Yes.
Same thing we have repeated.
Item 35.
Notice.
No, notice.
Notice limitation.
Limitation.
Notice on limitation.
Item 36.
My lord, before my learned friend begins, my lord, for the 220 days delay, your lordship may peruse the last two orders, my lord, before he begins, my lord.
No, but whether we should allow the limitation petition or not.
No, my lord, we have strong objection, my lord. 220 days delay,
200.
and the grounds are very inadequate, my lord.
Yes.
My submit minutes, I am appearing for the university appellant. Minutes, last date minutes, I have taken time to file an additional affidavit explaining the each day delay minutes. I filed that affidavit on 28/3/2024 minutes, giving the details.
When did you file?
On 28/3/March 24 minutes.
Is it there?
Physical. You have filed E mode. You have filed in E mode.
No minutes.
Physically.
Hard copy I filed.
Hard copy of it.
So we are planning to go for e-filing 100%.
Minutes. If you shoot that minutes, that's no problem.
But before that, we shall make necessary arrangements also.
Right.
It's not.
It is stated by learned counsel appearing on behalf of the appellant that an additional affidavit has been filed in support of the application seeking condonation or delay. First off, this said as additional affidavit is not there on record. Counsel this matter on 2 weeks with the said additional affidavit on record.
May I minutes, I'll prepare a detailed date chart, day-to-date basis. I'll also file that may be also tagged up minutes for minors better up.
Copy of the order. Certificate. I should so take it some other date for admission. Some other date for hearing.
As requested by the senior counsel. Let's this matter on. When do you want?
Need it subject to your lordship's consideration. Stamp reporting has to be done.
There is defect in the memo of appeal to the effect that no certified copy of the impugned order was filed. First off, the same is being filed in the court by learned counsel for the appellant. So let a fresh stamp reporting be done and the matter be placed under appropriate heading on 2 weeks.
Deeply. Obliged.
Item 38.
For the petition. Yesterday, I have also argued the matter in details out of yesterday, man. Telling the Naples matter.
Yes, yes. Yesterday you argued, then what did we do? We have forgotten.
Mother, page 14, mother. Page 14, the order of rejection. I'm placing the para 5, para 6, my lord. Having heard the learned counsel appearing for the parties and after going through the materials available in the courts, this court find that the petitioner's father was allowed to retire on the ground of permanent incapacitation on 16/1/98.
Yes, we have seen.
And by the order dated 5/12/1998 under Annexure 2, thereafter the order dated 13/1/1999, petitioner father relieved from his government service with retrospective effect.
Or let me remember now. Can we pass order?
The intra-court appeal is directed against order dated 20th December 2023, passed by the single judge in WPC OSC number 2809 of 2012, whereby the order of collector Cuttack order dated 26 September 2011.
After recess, we can, otherwise we don't have much time. In the second half, no. In the second half, we will. Next one. Next.
Item 39.
Because I had forgotten that.
Well, I am.
Right.
In this case also there is limitation. I have explained my delay ground that lordship can find it from IN number 665 of 2024.
So what is the delay?
49 days delay.
Yes.
49 days delay.
Yes, 49 days delay.
No delay for a stay.
Well, the notice it go only.
Issue notice.
My lord.
Item 40.
Point of limitation.
My lord,
Item 40.
item, yes, ma'am. In item 40, so there is delay, but your lordship will condone this and we can dispose of in terms of Bindusagar.
Bindusagar?
Yes.
We condone Bindusagar.
41.
Bindusagar, have you not gone to Supreme Court?
That is pending before
Supreme Court?
Yes. That is
Whether date of death or date of consideration
that
of application for rehabilitation.
And in Bindusagar, another point of view also is whether it is applicable.
That is referred to larger bench.
Not larger.
Our case is not.
No. And another point is involved in that Bindusagar, whether it is applicable to block grant schools.
Item number 41.
Yes, who is appearing?
Item number 41.
One appears on behalf of the appellant. Does this matter? 2 weeks.
Item 42.
Play prefer and short adjournment. Short adjournment allowed.
Adjournment.
My lord. Because the conducting counsel is ill, my lord, that's why I'm asking for short answer.
As requested on behalf of the respondent. Only one respondent.
Appellant. I am for the appellant. Appellant.
On behalf of the appellant, list this matter on 1 week.
2 weeks after.
2 weeks.
Item 43.
Item 43, 44, 45 and 46 are matters related to headmaster's scale of pay. And my lords will remember that my lords have already not heard, but my lords had taken up those cases and they were fixed. But in these matters, notice have to first do on limitation. Because there are 2 judgments on the same issue. So notice has to go.
Issue not, yeah, issue not is unlimitation. Limitation.
43, 44, 45 and 46.
Yes, same.
Item number 47.
47, my lord.
I am for the respondents. Since there is a delay, let a copy be served on us. I will file an objection to that.
What is the delay?
Delay of the 300 days delay. 300 and more.
No.
Let the copy may be served so that since
Yes, I will serve.
and after filing of
172 days.
after filing of the content petition, they have filed a show cause that they have filed a writ of appeal. Filing of the second content. So clearly the order has not been complied.
For a moment, my lord, may I take my lords to the order? For a moment, kindly. The order starts at page 79.
You are showing the order for us to dismiss your appeal or what?
I will leave it to my. I will see.
No, if sometimes may happen that unnecessarily why the appeal should remain pending.
Actually, my lord, I am trying to take my lords to the merit of the case.
Is it in your favor or?
In my favor.
Then let him file objection. As requested on behalf of the respondent, list this matter on 2 weeks.
Let a copy be served on us.
3 weeks, so as to enable him to file objection to the application seeking condonation of delay. Stop. Let a copy of IA number so and so. What is the number?
Number is, my lord, 827 of 24.
827 of 24 be served upon the counsel for the respondent in course of the day.
Yes.
After 2 weeks or 3 weeks? 3 weeks.
3 weeks. 3 weeks.
Okay.
For admission, item 48.
ठीक है मैं आपके निकल जाओ सबसे निकाले ऐसा नंबर 1 Petitioner is not present, another application of substitution is pending. That may be allowed.
There is no representation on behalf of the appellant. Learned counsel for respond number one,
What is legal error of number one?
counsel for
Number 1 to 1B. 1A to 1B.
respond number one is present. So, we'll discuss matter on 3 weeks. Then happen. Yes. No, what is, are they common?
No, they're different. Item 49 for 56 is different, 58 is total different. 58 is also hard little bit. My non-friend wants that because the advocate general is absent.
All right.
He wants that.
E58, you want adjournment.
No, we don't want. We don't want.
We are
State-
ready. The non-Daisy is not there.
Can it be on 18th or 22nd, whatever you want to suit your worship?
Just right.
Why we? I want to allow the job.
24th? 24th?
24th will do. Yes, we'll do it. One prayer. I have also, that is a formal prayer of amendment. Amendment means a prayer in the prayer portion, everything is there.
That will be taken care of.
That's it.
Oh,
That's it.
58, 58 will come on 24th.
Right.
At the same
At
time.
2 o'clock.
At
2
2
o'clock.
p.m. At 2 p.m. This same
p.m.,
time.
yeah.
2 p.m. Yes.
One just request in that item 58, the WPC 7715 of 2020. But that's a matter already, order is there to tag it along with these matters. Inadvertently slipped out.
The record is.
Forty-nine, 56?
Yeah, 49, I'm ready. I'm ready. I'm ready.
Item 49.
So.
This is the matter.
One minute, sir.
Please,
Sir.
one order is to be dictated and thereafter.
Item 38.
This intra-court appeal is filed challenging the order dated 20th. Challenges laid in the intra-court appeal to the order dated 20th December 2023, passed in WPC OSC number 2809 of 2012 by a learned single judge of this court, whereby the collector by order dated 26/9/2011, bracket annexer 5, has rejected the application for appointment under rehabilitation assistance pursuant to direction contained in order dated 11/3/2011, passed by Odisha Administrative Tribunal in OA number 4164, bracket C of 2010, filed by father of the petitioner, appellant, bracket petitioner in the repetition. Shorn of unnecessary detailed narration of fact, suffice it to say that the father of the applicant, electrician in the office of assistant agricultural engineer, Kalahandi, Bhavanipatnam, having applied for voluntary retirement on 16/1/1998, was allowed to retire with retrospective effect by order dated 5/12/1998, of the passed by Director of Agriculture and Food Production, Odisha, and consequential order of relief dated 13/1/1999, issued by Deputy Director of Agriculture, Kalahandi Range, Bhavanipatnam. It is asserted by the appellant at paragraph 3 of the writ appeal that, within quotes, after retirement of his father of the appellant, applied for appointment under RA scheme on 16/1/1998, quotation ends. It is alleged that though documentation was made and sent for approval of the competent authority, since nothing turned out successful, the appellant approached the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, in original application bearing number 4164C of 2010, which came to be disposed of on 11/3/2011, with a direction to the collector to consider the representation of the appellant. In pursuance of such direction, the collector took up the matter and rejected the representation. Thereby, the claim of the appellant for rehabilitation appointment has been refused, citing inter alia the following reason. Last paragraph at page 20. To ventilate his grievance, the appellant approached the learned Odisha Administrative Tribunal by way of an application under section 19 of the Administrative Tribunals Act 1985, which was registered as OA number 2809(C) of 2012, which was re-registered as WPCOAC number 2809C of 2012 before this court after abolition of Odisha Administrative Tribunal. The matter came up for hearing on 20th December 2023 when learned single judge has passed the following order. Para 6.1, page 14 and 15. Till the end. Hence, this writ appeal invoking Article 4 of the Odisha High Court Order 1948, read with clause 10 of the letter stating constituting the High Court of Judicature at Patna, and Rule 6 of Chapter 3 and Rule 2 of Chapter 8 of the rules of the Odisha High Court. Rules 1948. Mr. Ramnath Acharya, learned advocate for the petitioner, appellant, contended that the learned single judge committed error of law in sustaining the order of the collector in rejecting the application for rehabilitation appointment, inasmuch as clarification by Government of Odisha in General Administration Department dated 30th November 1998 clearly suggested that pending applications were to be considered in terms of extant position prevailing prior to the Odisha Civil Services Rehabilitation Assistance Amendment Rules 1998 came into force with effect from 8/10/1998. He pressed into service item 2 of said clarification, which reads as follows. Page 21. Valiant attempt has been made by learned counsel for the petition appellant to make it believe that since the case of the appellant was pending prior to 8/10/1998, as the father of the appellant was allowed to retire voluntarily in consideration of certificate of permanent disability with retrospective effect from 16/1/1998, even though order of the Director of Agriculture and Food Production was dated 5/12/1998, bracket Annexer 3, and order of the Deputy Director of Agriculture, Kalahandi Range, was dated 13/1/1999, bracket annexer 4. Sri Acharya therefore urged to show indulgence in the order dated 2012-2023 of the learned single judge and press for issue of writ of mandamus to the opposite parties to appoint to give appointment to the appellant under rehabilitation assistance scheme as was prevailing prior to 8/10/1998. The learned AGM, per contra, argued that there is no justification in showing any indulgence in the order dated 2012-2023 of the learned single judge. Subpara. He submitted that the statement made that the appellant applied for appointment under RS scheme on 16/1/1998 is a myth, as Director of Agriculture and Food Production allowed the father of the appellant by order dated 5/12/98, pursuant to which the Deputy Director of Agriculture, Kalahandi Range, by order dated 13/1/1999, allowed the employee to relieve. Therefore, the assertion of the petition appellant is not only false but also misleading. It is brought to our notice. No, attention is brought to the rejoinder filed on behalf of the petitioner, wherein it has been affirmed that page 50, this paragraph. The father of the petitioner, namely so and so, till approval. It is therefore submitted by learned AGA that prior to consideration of the case of the father of the petitioner appellant, the application for appointment of appellant under the Odisha Civil Service Rehabilitation Assistance Rules 1990 could not be considered by the competent authority. Be that as it may, the claim of appointment under the Rehabilitation Assistance Scheme being not matter of right, the collector has rightly considered the representation of the appellant, which needs no interference at this distance of time. The learned AGA has drawn attention of this court to the order of the collector, wherein it has been written as a matter of fact that the applicant has applied for his appointment under RS scheme on 26/7/1999 after acceptance of the retirement on incapacitation quotation ends. The impugned order of the learned single judge also reflects as follows. Quotation. There is no dispute that petitioner made his application to get the benefit of rehabilitation appointment on 26/7/1999. Under the aforesaid premises, it is argued by the DGA that though the father of the appellant was allowed to retire retrospectively with effect from 16/1/1998, since the orders of the director was passed after the cutoff date, that is 8/10/1998, on which the Odisha Civil Service Rehabilitation Assistance Rules bracket close amendment rules 1998 came into force. The appellant could not have made application prior to the said date, and in fact, factual position has transpired from the order of the collector as also the order of the learned single judge that appellant had made application on 26/7/1999. No infirmity can be imputed. Considered carefully the averments and taken into consideration the rival submissions upon hearing parties, counsel for the parties. It is manifest that the father of the appellant was allowed to relieve from duty from with effect from 16/1/1998 by order dated 5/12/1998 under Annex 3 and 13/1/1999 under Annex 4. For ready reference and better appreciation, the said orders are reproduced here in below. Annex 3 or Annex 4. Both correct. So fact of application for appointment under the rehabilitation assistance scheme by the appellant being on 26/7/1999, which were recorded by the collector as well as the learned single judge in order dated 20/12/2023. Unequivocal finding of fact as emanated from the record stands that since the appellant in the instant case made his application on 26/7/1999, that is after the cutoff date specified in letter dated 30th November 1998 in the clarification issued by the government in General Administration Department. The case of the appellant was not considered. More so, there was no objection, nor was any challenge laid to the orders of the director or the deputy director, allowing the father of the appellant to retire retrospectively. Next paragraph. Stemming on the it is settled position as to scope of writ appeal under the latest patent vis-a-vis interference with the finding of fact by the case law. This court made the following observation. Case law दे देंगे ना. So in the wake of above observations and for the reasons ascribed supra, in the light of discussions made in the foregoing paragraphs, this court finds no infirmity in finding of fact or perversity in finding of fact by the learned single judge. And there is no reason to differ from the conclusions arrived at by the learned single judge by the order dated 20/12/2023. In the result, next paragraph, in the result, having not found palpable infirmity in the order of the learned single judge, this writ appeal being devoid of merit stands dis, but there is no, in the circumstances, there shall be no order as to. Actual findings.
Please, yours. I prepared a very short date chart which will cover the entire background of the case. But in fact, this is a writ application, though it was argued last time, but recapturing your memory. We are the persons who have not been made parties before the division bench, and the order has been passed, which in fact we have filed this writ application to recall that order, review that order, because we are not parties, we could not have filed a review application in view of that judgment of the division bench, this court and also the Supreme Court. Just a placing order, you also recaptured it. 13/8/2007, a letter was issued by the DG of Police for filling of the vacant post of Assistant Station Officer in Odisha Fire Service by way of promotion as per Rule 660A of the Police Manual. But we are firemen, consideration to the, for promotion as per Rule 660 of the Police Manual. That letter was 13/8/2007. On 16/10/2007, a gradation list, that is nomenclature as a gradation list, public select list was published for promotion to the rank of Assistant Station Officer. In the said gradation list, the name of the petitioner found place at serial number so and so, so and so. That is annexure 2 at page 22. On 24/10/2007, an office order was issued by the Director of Fire Service of Odisha giving promotion to 20 number of candidates from the rank of fireman and Havildar to Assistant Station Officer out of the select list dated 16/10/2007. That is annexure 3 at page 30. Then 2/9/2010, I will mark this, these are some bearing. 2/9/2010, a letter was issued by the Director of Fire Service and Home Guard, Odisha, to the IG of Police 13/8, 2007 was issued by the IG of Police. Therefore, the letter was issued by the Director of Fire Service and Home Guard to IG of Police personnel Odisha, seeking clarification as to whether the select list, that is actually a gradation list, is valid for a period of 3 years or till it is exhausted. That is Annexure 4 at page 31. Then 11/11/2010, in response to the letter seeking clarification dated 2/9/2010, the IG of Police personnel Odisha clarified that as per the procedure laid down in PMR 660, in order to be eligible for consideration of promotion to the rank of ASI, a constable who have had 7 years of service after the period spent under the training are required to pass the written test as required under clause C of PMR 660, and there is nothing mentioned in the PMR about the validity of the select list, that is gradation list actually, list of the written test. That is Annexure 5 at page 32. Then serial number 6, you also look to this, 21/10/2010. That means after 3 years from the date of that gradation list was published on 16/10. This was on 21/10 after getting the clarification from the IG. More 107 number of persons were given promotion to the post of Assistant Station Officer out of the select list, that is the gradation list dated 16/10/2007 after 3 years of publication of the select list. Then 10/11/2010, again another batch, that is 18 number of candidates were promoted to the post of Assistant Station Officer out of the select list dated so and so by the DG and IG of Police. That is Annexure 7 at page 37. Then on 19/12/2014, some of the candidates who did not secure 50% of the qualifying mark in the pre-promotional test filed way number 516C of 2012 and batch of original application before the Law and Tribunal, challenging the criteria of fixing 50% of qualifying mark of the written test held in the year 2007, on the basis of which gradation list was prepared. The said original application were dismissed by the Law and Tribunal with a finding that 50% of the qualifying mark for filling of the post of Assistant Station Officer cannot be faulted with. Further, while dealing with the case of the said applicant, the Law and Tribunal made an observation at paragraph 9 of the order regarding the validity of that select list or gradation list. That is at Annexure A by 3 at page 17 of the counter. Then on 21/9/2015, challenging the judgment dated 19/12/2014 passed by the Law and Tribunal, the applicant in way number 3748C of 2014 preferred writ application bearing WPC number 16027 of 2015 before this Honorable Court. And this Honorable Court by judgment dated 21/9/2015 upheld the judgment of the Law and Tribunal with a finding that the writ petitioner have not implemented the person who have got promotion out of the select list dated 16/10/2007 as their necessary party to these cases. Then kindly see Annexure C by 9 at page 19. Then 26/2/2015, a letter was issued by the DG of Police for conducting the pre-promotional test again for the rank of Assistant Station Officer. Then serial 11, some of the selected candidates, like the petitioners, those names found place in the select list in the year 2007, filed original application before the Law and Tribunal with a prayer to quash the letter dated 26/2/2015 and give them promotion out of the select list dated 16/10/2007. Then 24/6/2015, the Law and Tribunal quashed the letter dated 26/2/2015 and directed the authority to act upon the select list dated 16/10/2007 to consider promotion of the applicant of the original applications. Kindly see Annexure B by 3 at page 30 of the counter affidavit. Then 1/2/2016, implementing the order dated 24/6/2015 passed by the Law and Tribunal in way number 651C of 2015 and batch of cases, 34 candidates, including the present petitioners, were selected, their names found place in the gradation list, selected for promotion to the rank of Assistant Station Officer and were directed to undergo the ASO course training for a period of 4 months. Because that is also as per the PMR Route 660. Kindly see Annexure 8 at page 39. 26/7/2016, the petitioner were declared passed and qualified in the ASO course training. That is Annexure 9 at page 39. Then WPC, out of which this writ application arises.
So this is there is some error here.
Sorry, sir. Sorry,
Annexure
sir.
8 is also 39, Annexure 9 is also 39.
I'm sorry.
Just find out.
Yes, sir. Yes, sir. Sir, I'm extremely sorry, sir. That is Annexure 9 at page, you please find out.
41.
Page 41. I'm extremely sorry. That's a mistake of my.
Sorry. Yes.
Then page 50, WPC number 13566 of 2015, some unsuccessful candidate who are not parties in the original application approached this honorable court challenging the order dated 24/6/2015, passed in OA number 751 of 2015 and batch without implementing the present petitioners in the original applications, and the person like the petitioners who have already passed the ASO course of training in terms of the order dated 24/6/2015, passed in OA number 751C of 2015. Then 6/7/2017, this honorable court passed a judgment in WPC number 13566 of 2015 and batch directing the state government not to give any promotion from the select list of the year 2007, thereby adversely affecting the petitioner as they have already underwent ASO course of training and were given promotion in terms of the order passed by the tribunal. This is the entire background. Now, at this juncture, before I take your lordships to the annexures and to the orders, I'll show your lordship the rules. First is Orissa Police Act, section 12. That is at page. Is it there? Orissa Police Act
has been enacted.
Yes, sir. That is 1861. That
1861 is Police Act, not Orissa Police Act.
No, the Police Act. Yes, right. I stand corrected. That's the Police Act, 1861. Yes, sir. Sir, kindly come to section 12, which is relevant for our purpose. 660. Power of Inspector General to make rules. I hope you also get it.
Yes.
Justice Raman.
Please.
Yes.
Oh,
The section.
just a minute. Just a minute.
Sir, sir.
646. Yes.
Power of Inspector General to make rules. The Inspector General of Police may, from time to time, subject to the approval of the state government, that's why underline, subject to the approval of the state government, frame such order and rules as he shall deem expedient relative to the organization, classification, and distribution of the police force, the places at which the members of the force reside, and the particular service to be performed by them, their inspection, the description of arms, so and so to be punished, the collecting and so and so. Skip over. Then the other provision which is relevant for our purpose, that is 660 of Orissa Police Manual. Orissa Police Manual. That is at page 342 of your, I think, say, books.
And what is the year of new Police Act?
Orissa Police Act. I hope that so far the Police Act is concerned, there is no other Police Act in so far.
Yes. Police Act has been enacted.
Orissa Police Act.
No, only Police Act. There are
Police Act
1881 is
that is a Police Act in 1988. That another one is 1949. That is just
another one, Orissa Urban Police Act 2003.
That is Urban Police Act 2003.
In fact, in the light of Supreme Court's direction, in case of Prakash Singh, the state governments have enacted, because the police is a
state subject. Yes.
Therefore, the state governments have enacted.
Right. We have not done it, but
Odisha has not enacted. That is the mandate.
Right.
Yes.
Yes, sir. Now you must kindly come to police manual 660, which is relevant to our purpose. 660.
Yes. Yes.
Your secretary. So for 660 small a, appointment of assistant sub-inspector. Assistant sub-inspector will be appointed ordinarily in the following manner. So for the qualification 1 and 2, we are not concerned, there is no dispute over that. You also just skip over to C, the selection. B is twice every year, all the SP and headquarters shall report to the IG of police, the number of vacancies, then we are concerned with C. The selection of both matric and non-matric constable eligible under the condition laid down in clauses 1 and 2 of subrule A will be made by means of a written test, which will ordinarily consist of law and rules and ability to write an essay in English. The marks for each subject at the time of to be allowed for each will be prescribed by the IG of police. The examination will be held centrally at a place or place to be decided by the IG of police. The answer paper will be valued by the examiner under a head examiner. So let's skip over. Then kindly come to E. The constable, after being selected by the selection board and allowed to officiate as ASI of police pending passing the final training examination, will not be entrusted with the duty to conduct. We are not concerned. Then selected candidate will be sent to designated training institute for institution basis course of ASI training as prescribed by the DG and IG of police. Then next is on successful completion of the training, the candidates will be placed in a state list to maintain at the state police headquarters on the basis of funds. This is substance of the 660. Now, sir, kindly come to annexure 1 to my writ application. At page 20. This letter has been issued by the IG of police. So may refer to my date chart, and I am just taking your lordships to those relevant portions of the letters which is relevant for our purpose. Page 20, sir. This is the letter. You also see the next page, page 21, issued by the IG of police of fire service on 13/8/2007. That is with reference to a letter by the fire officer. Your letter number so-and-so dated 24/4/2007. Promotion to the rank of ASO in Odisha Fire Service. Then you also kindly, in order to fill up the existing and anticipated vacancy in the rank of ASO by the end of 2007, a pre-promotional test is to be held shortly as draft fire service final as well as the draft OFS method of recruitment conditions service rules are yet to be approved by the government. The previous procedures followed for promotion to the rank of assistant station officer as prescribed under the Rule 66A of the police manual is decided to be adopted for filling of the post of ASO in Odisha Fire Service. The criteria for promotion is as follows. Matriculation, non-matriculation, Havildars must have completed 7 years of service after the period of spent under training. There is no dispute over that. Pre-promotional selection test that is written is to be conducted with the following subject, that is in terms of Rule 660A. Then 4 is minimum qualifying mark is to fix 50%. And this was challenged by some of the candidates, which was negated by the tribunal, 50%. Then 5. I'm reading it. The result of the pre-promotional test board shall remain valid for a period of 3 years or till the remaining rule by the government, till the remaining framing rule by the government, whichever is earlier. Let's see the bottom, IG and police, IG of police fire service. And admittedly, this has no approval has been obtained from the state government as required under section 12. Then you also kindly come to page 22. That is very important, which I found also. Page 22, after the written test was held in terms of 660A, this gradation list, also kindly come to page 22 top. This has been nomenclatured as gradation list for promotion to the rank of ASO. That is on 16/10/2007. Let's get it. That is at page 22. Then your lordship kindly come to page 30. Page 30. Page 30 on 24/10/2017 to 2007, 24/10/2007, this promotion was given on the basis of that gradation list. There is no dispute. 20 persons got promotions. But page 31, this promotion was given on 24/10 within a period of that 3 years, because the earlier the gradation list was prepared on 16/10. So this was on 24/10. But at page 31, Director of Higher Service addressed a letter to the IG of Police. IG of Police has addressed that letter, the Annexure 1. That one is 13/8/2007. Clarification was sought for by the director. Subject: validity of the list drawn in the pre-promotional test of assistant station officer in order to fill up the vacancy in the rank of assistant station officer equivalent to SI in this organization. A pre-promotional test, written test was held on 23/9/2007 as per EMR 66A. A copy of the letter issued to fire officer to this effect is enclosed here for reference. The board selected 310 candidates. Out of 50 candidates were allowed to promotion during last 2 years. It may be therefore clarified as to the procedure adopted with regard to the validity of the select list drawn by the pre-promotional board for promotion to rank of ASO, and whether the list remains valid for a period of 3 years as laid down in the GO dated 21/4/2001 or till it is exhausted. Then, sir, kindly come to page 32, the reply of the IG of Police. Clarification. This was on 11/11/2010. Orissa, from the headquarters of the police personnel, IG of Police, as per the procedure laid down in the PMR 660, in order to be eligible for consideration of promotion to rank of ASI, a constable who had at least 7 years service after the period spent under training are required to pass in the written test as required under Clause C. There is nothing mentioned in the PMR about the validity of the select list of the written test. Hence, department so and so, that is something different. We are not concerned. Then, sir, kindly come to page 33.
In that same annexure which you have read to us.
Yes, sir.
Page 32.
Yes, sir.
Clarification was issued that the result of the trade test board
yes.
shall remain valid for a period of 3 years.
That is a different thing. That trade test board we have. No, that is not concerned. We are not concerned. So that is for different employees. We are not concerned. We are concerned with that written test where a gradation list was prepared. Promotion out of that gradation list on 21/10/2010. That is, I'm just reading, because that was 16/10/2007. 3 years expired on 16/10/2010. This is on 21/10/2010. They issued this promotion letter. And this promotion letter in respect of 107, if you also will see, from page 36, begin from page 30 to 36, that 107 persons out of that gradation list, they were given promotion. Yes. That is after beyond the date, that 3 years date. Then, sir, again kindly come to, sir, page 37. Page 37. That is on 10/11/2010, 18%, another batch of 18%, the Central Selection Board held on 8/11/2010 selected the following fireman, leading fireman, driver, Havildar for promotion to the rank of Assistant Station Officer in Orissa Fire Service. They will be deputed to the Orissa Fire Service also, and on successful completion of training, they shall be allowed to hold the higher post of promotion. The result of final examination of ASO course and training should be sent to the director for fixation of the interest unit in the rank of ASO. This was on 10/11/2010. This 18 persons got the promotions. Then, sir, if you kindly come to page 39. So far as we are concerned, we the petitioner, total number 39, that has been now reduced to 33 or something, because some persons have left. Page 39. In pursuance, that is on 1/2/2016, because in the meantime, writ application was filed and other things. So therefore, the tribunal, some people approached the tribunal directed that you should give appointment. In pursuance to the Home Department letter number so-and-so dated 5/11/2015, containing direction to implement the order of the tribunal dated 24/6/2015, passed in way number so and batch, for promotion to the rank of Assistant Station Officer in Odisha Fire Service out of select list drawn in the year 2007 till its exhaustion. Such, the Central Selection Board (CSB) was convened on 19/1/2016 to assess the suitability of the candidates out of the existing panel in gradation list. You also mark it. Gradation list, that is Annexure 2, drawn during the pre-promotional test held on 23/9/2007 in order to fill up 34 number of vacancy in the rank of Assistant Station Officer by way of departmental promotion. The CSP scrutinized the nomination roll along with the service particulars of eligible candidate and selected the following candidate for promotion to the rank of Assistant Station Officer in their respective category as Megan mentioned against each. My name you will also find at serial number 11, Venudhar Behera. Is the petition number 1 and others are there. All, there is no dispute over this. Sir, then kindly come to sir page 40, next page. This was the order by the IG of Police, page 40. They will be, just after the name was, 34 names have been, then they will be deputed to Odisha Fire and Disaster Response Academy, Bhubaneswar, for undergoing Assistant Station Officer course training for a period of 4 months. On successful completion of training, they shall be allowed to hold higher posts on promotion. The inter-C seniority in the rank of Assistant Station Officer shall be fixed as per the outcome of the final result of the training course, because that is the rule. In the training course, so that will be given the seniority. So we have already undergone this training course. I have already placed in the date chart. Then also kindly come to page 41. This is the training course we have enclosed, and we are declared to have passed that training course after completion of 4 years. That is the page 41. Odisha Fire Service Disasters Response Academy 9th batch and course of training commanded from 1/3/2016. Result of final examination held from 18/7/2016 to 25/7/2016. Venudhar Behera also see serial number 11 and others are there. I may not spoil your lordship's time. Now, sir, kindly come to the judgment. Some candidates who are not parties before the tribunal, they filed the writ application, and what they challenge, if you also will see that at page 44, because that is the writ application. In the cause title, they have said the petitioner challenged the order dated so and so passed by the Odisha Administrative Tribunal in batch of cases and praised this honorable court to quash the same as it is unsustainable in the eye of law, and direct the opposite party to prepare a fresh list of candidates who have secured 30% of aggregate for promotion to post. That means they wanted to say that gradation list, the person, instead of 50%, that should be reduced to 30%. That is their case before this honorable court. And this honorable court, why I have agreed, Lord, you also kindly come to page 55. Page 55.
Yes.
The contention raised by the intervener that the order needs interference in view of the order passed by this court in WPC number so and so, when similar order has been passed to be proper by division bench of this court. Next part. We have gone through the order passed by this court in WPC number 16027 of 2015, disposed of on 21/9/2015, wherein the Learned Council representing the petitioner has confined his pair only on the selection of 18 persons in the vacancy occurred in the subsequent years. And a coordinate bench of this court, after taking into consideration the prayer which has been confined, has declined to interfere with the order passed by tribunal. That means 18 persons who were promoted subsequent to that after completion of after the period of 3 years, that was challenged. This honorable court, division bench of this honorable court, refused to interfere with that, because that was challenged on the ground. They have been appointed after expiry of 3 years, and that was this is the finding. And the ultimate conclusion, if you also will come to page 57, para 11. Para 11.
Yes.
We, after going through the order passed by the tribunal, have found that the tribunal has given no finding. You also mark it, but tribunal has given a finding with respect to the legality and propriety of the instruction dated 13/8/2007. According to us, that this 13/8/2007, where no approval has been obtained from the state government in terms of section 12(1) of the Police Act. According to us, and in view of the admitted position that there is no recruitment rule governing the field, hence, in absence of the statutory rule, the authority has got power to formulate the guideline by virtue of the executive instruction. The same has been done by the competent authority of the Fire Service of the State of Orissa by issuing the letter dated 13/8/2007, providing the provision and process of selection as Assistant Station Officer. We have also taken into consideration the legality and propriety of the promotion having been granted, taking into consideration Clause 5, to 3 years validity there, Clause 5 of the letter dated 13/8/2007, the selection process since been initiated in the 2007, the validity of the select list prepared on the basis of the said selection process would be valid for 3 years, that is up to the year 2010. We are making this observation on the basis of the fact that the validity of condition number 5 of the letter dated 13/8/2007 has not been questioned. However, we have already expressed our view that even the select list cannot be said to be valid for a period of 3 years or till the framing the cadre rule, whichever is earlier. But since, let's mark it again. But so far as challenging the 13/8/2007 is concerned, so far as we are concerned, there is no occasion at all to challenge that order because the clarification was made by the IG of Police. IG of Police has given appointment from that degradation list, and that is from time to time 107%, then 18%, then thereafter we have got the promotion. So then we also see this. But since the government, let's say I have some suggestion here.
Yes.
But since the government has given effect to the letter dated 13/8/2007, and the employees have already been granted promotion in pursuance of the same, hence we are not expressing our views regarding the promotion already granted. Stop it here, Lord. But if it had been stopped it here, then we have nothing to say. Those who have already got promotion like 107 or 18, we are also protected by that. But this next line, it was said, within the period of 3 years, as has been decided under condition number 5, letter dated 13/8/2007. That is how that we, the persons, though we have already got the promotion, out of that gradation list, the gradation list, our names find place, that is annexed 2. And that on the basis of that gradation list, after expiry of 3 years, promotion has been given to 107% first, then 18% next, then we have given promotion and we have already undergone the training course. The next page you'll also see, of course, the Honorable Coordinate Bench have passed this order. Paragraph Roman 2. The state government would not grant any promotion from the select list, that is gradation list, no one as gradation list, but created as select list, prepared on the basis of the selection conducted in the year 2007 for the region stated. Now, so far as for the coming month, after the judgment was passed, if they will not give appointment, we have nothing to say. But we are the person, we are just stands on the same footing like that of that 107 or on 18. Now, one question may arise, the negative equality. Here, the question of negative equality doesn't arise because that very letter of the IG of Police, that is not in terms of the provision of section 12(1). This is just a letter, and a clarificatory letter has been issued subsequently. And by virtue of that clarificatory letter, the IG of Police himself has given promotion beyond 3 years to 107 and 18 persons. So far as this Roman 2 is concerned, we have nothing to say. But so far as if your Lordship will, last time your Lordship wanted to say that if it is a review, you have not been made parties, why not we will recall and we will hear that matter. That was your Lordship's suggestion. But what I was suggesting, if your Lordship will say that within a period of 3 years, if that will be deleted, we are also protected. Because we have already undergone the training. So now the whole question for consideration of your Lordship is that so far Annexure 1, that letter dated 13/8/2007, which the IG of Police himself has clarified subsequently. This is, had it got the approval of the state government, it would have been something different. This is the law. So therefore, we are bound by that. Then the question of even if some persons have got the promotion, your Lordship can say that you can't take the advantage of negative equality. But here is a case, these 35%, there is nobody else, 34%. Out of 34%, I think there is only 20 or 29% are there, what I was told. So these persons have already undergone training and they have already got whatever, only they will be allowed to continue in that promotional post. And judgment I have brought for your Lordship. I have prepared a note of submission for your Lordship and a very short note of submission. That's fine. They did. This is my entire case. I've boiled down to I'm reading one. Note of submission. Subsection 3 of Section 26 of the Orissa Fire Service Act 1993 provides that, inverted comma, until rules are made under this section, the rule in force immediately before the appointed date and applicable to the officers and staff of the fire service branch of Orissa shall
But
as far as
in this writ petition, your only grievance is that in WPC number 13566 of 2015, you were not in pleaded party
Right.
and you were not heard.
Right.
The order was passed behind
Behind
your
my
back. Therefore, that order should be recalled and that writ petition should be restored to.
Yes, sir. But so far the state is concerned, I've just bring to your lordship notice. In the judgment, your lordship will find they were supporting our case throughout. Their contention was in favor of these persons. That has been recorded by the division bench. Now what has happened? Because a new rule has come into force in 2021. Now the states, as last time they took a plea, that because of the new rule, we have to make a plea, again a recruitment test and other things. That is what they said. And another thing I must bring to your lordship notice, that is my duty. One person amongst these persons, I don't know who is he, but he filed an application for intervention in that division, before this division. We are not, all these persons, they are not, one person. And that person had gone to Supreme Court. And Supreme Court at the stage of admission of this SLP application was dismissed. And you also note that merger principle will not be applicable. Even if SLP dismissed, review is always permissible, though judgment I have brought. That's your lordship with experience. I'm showing that. So therefore, in any case, we, the person who are adversely affected, we have not been made party. We are not made parties, and order has been passed behind our back. This is more or less. May I place that note below? Just for your lordship, sir. That is also, I've taken that down. Subsection 3 of Section 26 of the Orissa Fire, sorry. Which was sought to be reviewed. What is the state stand? Let's just have a glance. Page 48. The learned additional government advocate, Mr. M.S. Shah, from counsel appearing for the intervention also, they have submitted that there is no rule formulating by the state government governing the recruitment of the promotion rule for the post of assistant station officer. The government in such a situation has adopted the provision of Rule 660A of the police manual. They have submitted that the provision of Rule 660A of the police manual does not contain any time limit. As such, once the list would be prepared on the basis of the pre-promotional test, it would remain valid till it is exhausted. This is the stand of where the state is concerned all through. May I place the note of submission, then I will proceed down. Subsection 3 of Section 26 of the Orissa Fire Service Act 93 provides that, inverted comma, until rules are made under this section, the rules in force immediately before the appointed date and applicable to the officers and staff of the Fire Service Branch of Orissa shall, as far as they are not inconsistent with the provision of the Act, continue in force and apply to the members. This is the 26 subsection 3. As there is...
The writ petitioners are here. The writ petitioners of the earlier case. Yes.
I think they have been implemented. I have implemented as parties, but they have not, most of them have not appeared. Because they have appeared for 1.
9 and 10. I have appeared for 9 and 10.
As there is no cadre rule made in respect of the fireman at the time of appointment of the petitioner, the procedure laid down in Rule 660 of the Police Manual are being followed for promotion of fireman to rank of Assistant Station Officer. 2. As per the PMR 660, a fireman Havildar having 7 years of experience is eligible for promotion for appearing in the written test, and candidate after successfully declared passed in the written test are considered qualified for promotion to the rank of Assistant Station Officer and are sent for training, and thereafter appointment is given to the promotional post. Section 12 of the Police Act confers power on the Inspector General to make rules. As per the said section, prior approval from the state government is mandatory for framing of orders and rules as it shall deem fit relative to the related to the organization of the police force. So far as Rule 660 of the PMR is concerned, the same is silent about the validity of the select list. Further, the authority, while fixing the 3 years validity of the select list, no prior approval from the state government was obtained, even though such prior approval is mandatory as per Section 12 of the Police Act. Therefore, the fixation of 3 years of validity of select list is in clear contravention to Section 12 of the Police Act. So far as the present petitioner are concerned, they are directly affected by the impugned order, since they are not arranged as parties in the WPC number 13566 of 2015 and batch before this honorable court, even though they are promoted and declared to have passed and qualified in the ASO course of training by implementing the order dated 24/6/2015, passed by the Land Tribunal in way number 751 of 2015 and batch. Therefore, in absence of necessary parties, present petitioner, the order passed by this honorable court is not binding and is a nullity. That is the language of the Supreme Court. The Honorable Division Bench did not take into consideration of the fact that the present appellant were selected for promotion, and accordingly they were sent for training and even successfully completed the training. 7. It is an error of records stating that the Land Tribunal did not give any finding with regard to the validity without any speaking order. So the doctrine of merger is not applicable in the present. Select list. Land Tribunal has rightly referred to 660 of the PMR. Then 8. The impugned judgment has no observation. In the impugned judgment, there is no observation or finding about the PMR 660, though the competency of the IG of police to fix the validity of the select list of 3 years was argued before the Land Tribunal, and the same was accepted by the Land Tribunal in way number 751 of C of 2015. Even assuming, though not admitting, the contents of the affidavit filed by the state was directed to file an affidavit. They have filed an affidavit that what action you have taken after the judgment in respect of 107 persons. 107 persons. Even though assuming, though not admitting the contents of the affidavit filed by the state on 22/8/2023, that the 107 candidates were recommended for promotion within 3 years, which they themselves accepted that is the error of record, that is beyond 3 years, that they have accepted that. Were recommended for within 3 years, but admittedly the promotion has been given to said 107 candidates after 3 years. Furthermore, the recommendation of 18 candidates was made beyond 3 years, and accordingly promotion was given to such candidate after 3 years, which is not a nullity. Therefore, the principle of negative equality cannot be applied to the present case. As can reveal from the impugned judgment, the state government had throughout supported the contention of the petitioners. Unsuccessful candidate approached the Land Tribunal in way number 516 of 2012 and batch with no prayer with regard to the validity of the select list, but fixing the minimum qualifying marks to 30% instead of 50%. Though one of the interveners, after dismissal of the writ petition, approached the Honorable Apex Court by filing the SLP, but such SLP was dismissed without any speaking order. So the doctrine of merger is not applicable in the present case, and the impugned order is amenable for review before this Honorable Court. 13. It is humbly submitted that candidates who were unsuccessful and were not parties before the Land Tribunal in OA number 751C of 2015, that is opposite part number 9 and 10, my Land Pen is appearing, directly approached this Honorable Court in WPC number 13566 of 2015 and batch, challenging the judgment passed by Land Tribunal in OA number 751C of 2015 without preferring a review of the said judgment in any case if they are affected by the judgment passed by the tribunal. They had the opportunity to file a review, not straightly come to this honorable court challenging the judgment. Insofar as 2021 rule is concerned, the same cannot be made applicable to the present petitioner, since by the time the rule was enacted, the present writ petition was already pending before this honorable court. So it is well settled that during pendency of any proceeding before the court of law, if any rule or act is enacted, the same cannot be made applicable to the parties, as the same would relate back to the date of cause of action. And I have prepared also a memo of citation for your lordship's convenience. I think that has already been given to your lordship's flag X of your the office. Yes. The first judgment I have shown to your lordship 2004 6 SCC page 126. That is that Polasing case, because we have not been implemented as a party, we have a right to file a writ application to recall that judgment. Then the second is important. In absence of a necessary party. Sorry.
Like X. Yes.
Yes, sir. That Polasing case, you also knows that 2004 6 SEC, page 126, that is at page that starts from page 2, paragraph 18. I need not praise that as a right also to file a review application, because they are not parties to the original application. They could not have filed a review application. And so far, not in absence of necessary party, the order passed is a nullity. That is also first judgment I am showing, 2022 Supreme Court, page 2550. That starts at page 12. I have page marked in the ink. That bunch of judgment I have given, that starts from page 12. And the relevant portion, paragraph is paragraph 28, page 19. Para 28, page 19. Does you get it? In any case, non-joinder.
Yes.
In any case, non-joinder of a necessary party go to the root of the matter and could also be fatal to the legal proceeding. For this, we can usefully read the opinion of the court in Khetrabasi Vishwas case.
Settled position, Pramod Barma.
I did not place it. The other judgment I have Khetrabasi Vishwas I have given, that is at page 21. That you I need not repeat it. And so far the dismissal of the SLP is concerned, that also your lordship is well aware. I just want to bring to your lordship's notice, that is page 23. Code Distilleries Limited. Para 8 and 9. Para 28, sorry, para 28 and 44. Page 44. Page 40. Para 28. Sorry, page 27, para 9. The question of law.
Yes.
The question of law which needs to be determined in the aforesaid circumstances is as to whether review petition is maintainable before the High Court, seeking a review of a judgment against which this special petition has already been dismissed by this court. Then, sir, kindly come to page 34, the conclusion. Sum up is para 44. Para 44. To sum up our conclusion is this. You must skip over Roman 1. Next page 35. Roman 4.
Yes, please.
An order refusing special leave to appeal may be a non-speaking order or speaking one. In either case, it does not attract the doctrine of merger. An order refusing special leave to appeal does not stand substituted in place of an order under challenge. All that it means is that the court was not inclined to exercise its discretion so as to allow the appeal being filed. Then para 5 towards bottom. But this does not amount to saying that the order of the court or tribunal or authority below has stood merged in the order of the Supreme Court, rejecting the special petition, or that the order of Supreme Court is the only order binding as res judicata in the subsequent proceeding between the parties. That is para 5 towards bottom. Then para 6. Once leave to appeal has been granted, that's a different, granted, and the appellate jurisdiction of the Supreme Court has been invoked, the order passed in appeal would attract the doctrine of merger. That, you know, so these are, I have also given another judgment of the that Kunal Mathur versus State of Kerala, that is at page 39, reported in AI 2000 Supreme Court, page 2587, I've given to you. So this is my sum and substance of the entire argument.
Yes.
I will not repeat, I will assist what points he has done. Only from that I'll pick up. Your Lordship, that section 12 of the Police Act, we said that the IG can frame the rules subject to approval of the state government. In 2 or 3 cases, they passed orders. They came well before a Lordship for consideration, and that point is no more recent integral, where your Lordship has said that section 12 stands on the way if the rules have been framed but without approval of the state government. That point is no more recent integral. That 3 years condition given here, there is a gray area in that rules. 3 years they have framed, but without obtaining prior approval of government, and that judgment, that point was considered by this court, and in
No,
2003.
but there may be executive instruction kind of a thing, which may prescribe that the life of this panel or the test shall be, result of the test shall be 3 years. There may be a kind of executive instruction.
Executive instruction issued by the state government can substitute the gray area of a rule. Here is the case, a head of the department has framed a rule without approval of the state government. That is the point. That point, that letter, without approval of the state government, that point has been answered by your Lordships in an earlier division bench, and para 9 it helps that. Can I send it?
Referring to that letter, the
No,
same
no,
letter.
not this earlier case. On earlier occasion, very DG police framed some rules that this court overruled because it was not having the prior approval of state government, with reference to section 12 of the policeman. The view of this honorable court,
That language is very clear.
Nice.
That any decision of the
DG police,
IG police, not DG police, IG police shall have statutory force unless it is approved by the state government. It will partake the nature of statutory rules. Otherwise, we may issue executive instructions.
Yes, that will not have the binding effect on
that.
That will not have a binding effect because of this clause in section 12. Otherwise, in ordinary parlance, your Lordship, state government has framed some rules. Gray areas, state government can issue executive instruction to fill up the gap. But here is the case, it's not because of the language.
If this submission of yours is accepted, then if there is gray area, then there should be no promotion.
The promotion can be given. That limitation is not.
No, promotion.
That limitation. That limitation of 3 years is not. It is, that means it's open. All the decisions of your Lordship.
That is different. That your submission that in the absence of any limitation prescribed under the police manual or under the act,
the gray area, I said
the life of the panel should not be allowed to die, to lapse. But you cannot say that because of the gray area, nothing can be done.
That says that list will always be there, a running list.
See, I am giving you an example. If there is a provision that appointment to this particular post shall be held on the basis of a competitive examination. All right. Now, in order to enforce that, if the IG issues an executive instruction that this shall be the competitive examination, these shall be the papers, this shall be the minimum marks which a candidate must score. You cannot say that this is not binding. This is executive instruction. It does not have any statutory force, but yes. So this is how.
That is what
all right.
Your Lordship examined. Those two judgments are.
Anything else? Yes.
And if your Lordship remit this matter to the division bench for rehearing, you will get a chance to address your Lordship.
Yes.
My lord, I am appearing for the 9 and 10.
With
OP 9 and 10.
OP 9 and 10. The only question is
My lord,
that
only.
when you file the writ petition,
Yes, ma'am.
you did not implead these persons who claim to be the necessary parties.
My lord, they are not necessary parties, ma'am. Because they are not party to the earlier way, or they are in these two way are challenged. One is 75759 group and 13532 group. They are not party to this. So we need not have. And moreover, they do not get promotion till then. They have not got promotion. When we have filed the writ application, they have not got promotion. They have not even considered for selection. There is a selection board is there. They have not considered for selection. Then why shall he make them party?
So had you not filed writ petition and had there been no such order, they would have been promoted or given promotion.
That's right, madam. But what is my thought?
So whether filing of your writ petition,
yes,
or passing of the order by the division bench prejudice their case or not? No.
Yes.
That whether that adversely affected their cases or not.
My lord, one more thing they have not stated, and it is wrongly also interpreted. My lord, your lordship see first annexure 1. In order to fill up the
in order to fill up the existing and anticipated vacancies in the rank of ASO by the end of 2007, a pre-promotional test is to be held
Shortly, as the draft.
only for a vacancy. The pre-promotion test was held for 2 vacancies.
2000, end of the 2007.
That is the 20 vacancies.
My lord, just a minute, my lord. This is end of 2007. Vacancies for 2007, end of 7. My lord, your lordship see my counter. My counter, first annexure. First annexure, first paragraph. Annexure A by 9. It.
A by 3.
A by 9.
A by 9.
Page 8.
Page 8, A by 9. 9 and counter is 9 and 10.
Yes.
Last paragraph.
First paragraph. That in order to fill up 20 vacancies in the rank of assistant station officer, a written test was conducted.
We have understood your submission. So according to you, this letter was.
In that case, the government has.
Just a minute.
Yes, madam. This is for 20 vacancies.
This letter was issued only to fill up those vacancies which were existing on the date of issuance of this letter, dated 13/8/2007. This is your submission. So beyond this, no
question of 3 years.
Vacancy could have been filled up, no promotion could have
Yes,
been granted.
yes,
This is what you.
my lord, your lordship see annexure B by 9. Government has filed a counter. Government has filed a counter.
In this case.
In this case, man. 1356. Government has filed a counter in 13566.
13566.
Yes, ma'am. This I have given a counter to this case.
Okay.
Annexure B by 9, my lord. In this case, present case. Your lordship see an A by 9. Now your lordship see B by 9.
Page 14.
Page 40.
Page 15. Your lordship come to page 16.
Internal page 2.
Internal page 2. Running page 16.
Yes.
Total number of officers in the year 2007.
Total number of candidates.
Total number of candidates.
Total number of candidates qualified in pre-promotional test for promotion to the rank of assistant station officer in 2007 is 310 numbers. Central Selection Board CSP was held on 24/10/2007
to fill up the number of posts of ASO, that is 20.
Yes, let's stop that. Well, at 20, if 2000, at the end of 2007, 20 vacancies and 20 people are appointed. Within that 3 years, within whether it's 3 years or not, but it is within time for which it is conducted. So my lord, once there is 20 vacancies filled up, there is no vacancy for that year. For other years vacancy, your lordship see they have given year-wise vacancy position, year-wise vacancy. In other years vacancy, how could we fill up in 2007 per exam? They specifically stated that. End of 2007.
See, this plea you are raising for the first time in the present appeal, in the present petition.
No. We have made it, but they have not stated. But in the past way.
You are also appearing. You are also appearing.
9 and 10. She's
Mr. Counsel, you are also appearing.
He is appearing. Actually, I am not appearing. In all these cases, I am not appearing. In this case, only I appear.
No, you are assisting Mr. Kalyan Patnaik. You are assisting Mr.
In this case.
So do you have faith in him? Please take your chair. If you required, you can assist. Yes.
My lord, your lordship, see, there is 20 vacancy only. After 20 vacancies.
No, whether 20 vacancies were there or more vacancies were there, whether this plea was taken in the writ proceeding. Is there any finding in the writ proceeding?
No. There is no finding.
So they did not have any opportunity to deal with this aspect. You may be right in your submission. But should we, in the present proceeding, decide this?
But present proceeding, my lord, in present proceeding, we have filed OA. Some other persons, some successful candidate, 5759. These two cases, thereafter we are suffering. If this allowed to stay for this stay, we never get promotion till we retire. Because all the 300 persons will go and we will be there. We'll suffer. We have appeared, we have, and we never get promotion.
All right, very good. Did you appear in the examination?
Yes.
So you were given an opportunity. You had an opportunity to succeed.
That's the tribunal say that you have appeared in that exam and you cannot challenge. You have accepted the norms and you cannot.
As has been submitted, your contention was that the cutoff marks should be reduced from 50 to 30.
30%.
This was your case. It was not your case that for that year only 20 posts were there.
Well,
they should not have been
whether we have taken it the plea or not, but that is itself there.
That is itself there, then they should have, they must have, they had a right to take a plea when your matter was being heard.
My lord, this is 30%. My lord, there is something wrong somewhere. I don't know. I am not appearing there. That is 50%. There is another decision of this Honorable Court Division Bench decision.
Sir, was this your stand at any stage that this cutoff marks should be brought down to 30%?
Yes, my lord. In both the cases, this 30%.
How can you argue? How you are on the one hand you are saying that was confined to
my lord,
at the same time
my lord, we have cited a decision of this Honorable Court, wherein the police department also they have a 50% and they reduced to 30% by the orders of this Honorable Court. Nowadays also 30% is still continuing by the judgment.
So you want 30%?
But that we have lost.
Perhaps there was no rule that it should be 30%, and the norm could not be cited by the
there is no rule,
concerned.
but they always follow the police.
I was party to that judgment while sitting in court number 3.
Yes, I know that. Yes, fine. You also turned down that.
petition has no fault because they are not necessary party. They are not necessary party.
We have understood your submission that because the mere the fact that their names figured in the select list did not give them any right to be appointed. Therefore, they were not necessary parties. This is your submission.
No. They are not party to the earlier. We have challenged two OA. One first OA we have filed. We ourselves have filed. 9 and 10 both have filed 2 OA. And 759 successful candidate have filed. We have nothing to do. But in that case, they say that it should be eternal until 300 posts are filled up. Then we are affected. Because we won't get the promotion at all till our career. If other exams.
All right. Had you scored 50%, whether you could have got promotion or not?
We have unsuccessful. We have unsuccessful.
Oh, we are just putting a hypothetical question.
If 30% will get.
Had you scored 50%, had you scored 50% in that examination,
yes, ma'am.
Whether you would have had chance to be promoted or not?
You have chance to promote.
Because you failed, therefore, during lifetime you will not. This is your grievance.
No, my lord, if we will fail, it is not that. My lord, if it is at that time, it is.
Mr. You are blowing hot and cold.
No, man.
You are.
No, my lord. If 20 posts are full, next year there will be exam. Because your lordship see.
This plea you are taking now, this plea you had never taken, it seems. This was not your plea, that this examination for 1 year only.
We have taken that point. We want that to quash the Annexure 1. We have taken not in so many words what I have told now, but we have said that to quash Annexure 1.
But you are relying on Annexure 1.
No, that's why we said that another exam should be there.
No. You are saying that was only for existing and this is what you want. Your whole argument is based on Annexure 1.
In a way, my lord, we want that to quash this Annexure 1.
All right. You may be correct, you may not be correct, we don't know. But these aspects could have been thrust in that writ petition.
My lord, I can't improve the position, my lord.
No,
the judgment is there. I can't improve the position. Right. But that is
but you have been very fair to the court. We must compliment you for this. We are very happy.
Very specific. 3 things I will bring to my mind. What is on the chart? What was 13/8/2007? If 13/8/2007 gave rise to 2 things. One, it declared a list. 2, it said to be sent for training. Now, annexure that 13/8/2007 is an exercise of power. As you told to, the part of it cannot be said to be beyond the competency, and part of it is with competence. It cannot be argued like that. This is my first concern. Then my lord, kindly draw my lord's attention to my count.
Yes.
I did not read again annexure that 13/8/2007 from it, my lords have already seen it. Now, my lord, kindly come to my counter. Count of file by the opposite party 1 to 5.
Yes. Yes.
Now, I will take my lord to page 17 of the count.
Yeah.
Kindly take my lord to ask, no, what was the scenario? My lord, kindly see page 17. These were the batch of 5. 13/8/2007 is the list, as my lord has already read out to my lord.
That is A by 3. A by 3. Annexure A by 3.
20% given promotion, thereafter 107, thereafter another 18. This is 2012. Kindly see, this is 2012. The batch of OAs were filed, wherein the petitioner therein, the applicant therein, they said, please reduce the qualifying mark to 30%. That was rejected. While rejecting that, may take my lord kindly to that page. Page 28.
Page 28 of your counter affidavit.
Ma'am, page 28 of that order. Okay, shown to my. I'm reading one part. With regard, this is the finding of the tribunal. In 2012 batch of cases where they were seeking 30%.
86, page 86.
Yes.
With regard to the contention of the applicants that after expiry of validity period of 3 years, 18 candidates.
Para 9, para 9, para 9 of.
Yes.
With regard to the contention of the applicants that after expiry of validity period of 3 years, 18 candidates have been given promotion from out of the select list dated 16/10/2007. The
Yes.
respondents in paragraph 5 of the counter submitted that as per provision in CMR 660A, there is no such restriction for confining the merit list for the period of 3 years. As per letter number 47172 dated 11/11/2010 and the B to the counter issued by the IGO police referred to Home Department letter number 23642 dated 21/4/2001, the validity period of 3 years is only applicable in respect of select on merit list of the candidates who came out successful in physical and written test in trade test board, which is being conducted in respect of technical services in police motor transport and signal establishment. Even though there is no specific provision in PMR 660 as to the validity of select list and validity of 3 years is given to the select list of technical personnel, there is no validity period of select list for ASI police, which does not appear to be logical and correct administrative framework, as this deprives successive batches of firemen for promotion to ASOs, especially when there is validity of 1 year for select list in case of direct recruitment promotion in other departments. With this conclusion, the tribunal dismissed all those OS, where the prayer was, of course, to reduce it to 30%. Then, my lord, may kindly come to the next, annexure B/3. Now, this is important here, my lord, for this. My lord, may kindly examine who are these persons. These three OAs, 751, 723, and 939. My lord has already seen that 20 persons got promotion, then 107, then 18. These are the persons below them. Because my lord has already seen 310, a select list has been prepared. These are the persons like the petitioners who are before my lords. They have challenged. What they have challenged, my lord? They have said, because in 2014, government came with a fresh notice for a pre-promotional selection. That was challenged by these persons who were identical to the persons in the petition before my lords now. Because they are below in the list. They were nowhere in the parties, my lord, in no case. Now, my lord, may kindly see, in this case, the tribunal directs that no. My lord, may kindly see the order. May I take my lord to page 45?
No, these read petitioners, those who are before us in the present proceeding,
my lord,
they were not parties to any proceeding.
No.
So these read petitioners, when you say these read petitioners, then you refer to the writ petition which has been disposed of.
Yeah. Yes, ma'am. I'm sorry. Yes, ma'am.
And I got confused for a moment.
My lord, the way applicants.
I think what he said is that in both the writ petitions, now and the earlier, they were below, down below.
Yes.
No, these petitioners for the petitioners of the present petition.
Yes.
No, they were below 107.
Well,
and had you maintained that the principle of promoting them on the basis of panel which you had prepared, they would have been promoted.
Yes. My lord, they probably could have been promoted, but because of my lord's restriction of 3 years, that could not be worked out.
All right.
Now, what I am trying to impress upon this honorable court, my lord, is who were these OA applicants? They were the persons like the writ petitioners before this honorable court now, seeking that, yes, you please work out that list. And these OA applicants
No, these OA applicants were them, not them.
Yes, OA applicants were, no, my lord, not even the persons represented by my Lord Senior Mr. Patnaik. No. These persons were the persons who were below the list and could not get promotion.
All right. And they had scored 50%.
They had scored 50%.
They were also there before the.
Yes, ma'am.
Tribunal. All right.
Now they challenge. So they are
So whether
identically
they were
placed.
those who.
Let me place my lord, may kindly see what is the order of this tribunal. Now, my lord, may kindly come to base 45.
That B by 3, annexer B by 3.
My lord.
Page 45.
No,
My lord.
let me tell you. 45.
If because some disputes are coming, may I take my lord to page 31? What was the case? What was their case before the tribunal? Para page 31. Para 2.
30, page 31 of
Annexure B by 3. My lord is holding annexure B by 3.
Yes,
That
sir.
starts
Yes,
at
sir.
page 30.
Running page 89.
Page 30,
31
31.
of the counter, man.
Yes.
Running page 89, as my lord senior was saying.
89.
So these were the persons who had qualified.
Yes.
All right.
Now, my lord, the tribunal, they said, please work out the list. You cannot you cannot stop it here. In 2014, when government said another fresh recruitment.
All right. So this OA number 70, 751.
751,
All right.
723.
Any order passed by the tribunal in this case was challenged.
Yes, ma'am.
So whether they were parties.
Now these persons 751 Dhruva, they are parties here. Now, my lord, what I am trying to submit before this honorable court is the writ petitioners before my lords were what, my lord? They were beneficiary of an order. I admit, my lord, they were beneficiary of an order, but they were not party. Because of the order of the tribunal at page 45, they got the benefit. They were not parties.
Yeah.
Now, this order of the tribunal was questioned before this honorable court. So, though the petitioners who challenged this case, they have maintained because they have made all the way applicants as parties. My lord, my respectful submission, I will only rest there. Whether they could have made, they could not have made, I am not going to submit for that. But the position of law is these writ petitioners were never a party, nor they exercised any approach the tribunal at any point of time, seeking that please carry out this list. They were, of course, beneficiary of an order. Now, can they be termed as necessary of proper party, man? That is my second humble submission before this honorable court. Now, my lord, may kindly see what is the tenor of that order. Page 45, may I read, please?
103.
My lord, that will be
running page 103.
My lord.
Thus concept.
Does
You have the running page.
Conspectus.
Thus, on a conspectus reading, my lord got it.
Yes.
And relying on the judgments referred to above, the observation made in para 9 of judgment 516C of 13, the earlier one which I was reading, cannot be construed to be the ratio decidendi of the judgment, which has any binding effect. No direction has been issued, which is required to be complied by the respondent authorities. It is an expression of opinion only without there being any adjudication. As there being no issue as to the validity of the select list, the stand of the respondent that the issue has already been adjudicated adjudicated, therefore is not acceptable. The respondents in their counter in OA 516C of 2012 have averred that the merit list is not confined to 3 years. In view of such admission, there cannot be any issue on this point. Issue arises when a material proposition of fact or law is affirmed by one party and denied by the other. The grievance of the applicant in OA number 516 of 2013 is to lower down the qualifying mark, and for that, their prayer was not to give effect to the said select list. When admittedly Rule 660 of the PMR, which do not provide any time limit the select list which has been prepared by Annexure 2 is to be treated as valid and remain in force till it is adjusted as has been done in general police. With this view, it was directed, my lord, it was allowed, and the London Tribunal directed what the direction was. My lord, may kindly see. In view of the foregoing analysis, my lord, I am reading the last paragraph. We conclude that the present OA is not hit under principle of res judicata, as the judgment in OA number 516 of 2012 in para 9 has no binding effect and can be treated as the ratio decidendi of the judgment, and consequently, as Rule 660 of the PMR do not prescribe any time limit, the select list by Annexure 2 shall be kept valid till it is adjusted. Accordingly, though is allowed, the order dated 26/2/15 by Annexure 11, by which a fresh promotional board was constituted, of respondent 2 being not maintainable its cost, and consequently, respondent authorities are directed to act upon the said select list to consider the promotion of the applicants to the rank of assistant station officers. My lord, after this order, 34 candidates' names were prepared. To implement this order, in this case, the writ petitioners were not parties. Now that order was challenged before this honorable court. And this honorable court stayed. Then finally, my lord has already seen what is the order. It has gone to Supreme Court. Confirmed. Now, only I will conclude, my lord, with one last annexure. My lord, may kindly see annexure, page 48. Annexure C/3.
Annexure?
Annexure C/3. A case with similar prayer was rejected by this honorable.
Yes.
May I read that, ma'am? This is a wholly misconceived writ petition, where the prayer is for recall of an order passed by a division bench of this court more than 4 years ago in another writ petition to which the petitioner is not a party. Despite repeatedly telling the London Council for the petitioner that such a course is not available in law, he is not prepared to relent. He then says that he should be permitted to amend the writ petition by changing the prayer clause. Merely changing the prayer clause will not help the petitioner in any way, leaving it open to the petitioner to seek other appropriate remedies as may be available to him in accordance with the law. The writ petition is dismissed. Now, my lord, with this scenario, my lord, I have already said that it has gone to Supreme Court, and my lords here in the writ, while confirming, while turning, setting aside the order of the tribunal, has directed us to frame a rule. We have framed a rule. Now, my lord, this is my submission on this case, my lord. Now, my lord, I have another submission to this honorable court. Now, there are, my lords are hearing WPC 19875 of 2019, and my lords have already seen the prayer, where the order passed judgment of this honorable court is being sought to be reviewed or recalled, my lord, what? But in the other case, my lord, that is 30991 of 21, it is not same, my lord. I must bring it to my lord's notice. It is not same to the writ petition 19875 of 2019. There, virus of the rule is at the challenge.
The second sub-item.
Yes, ma'am. And therefore, this, where a virus has been challenged, cannot be said to be similar to this writ petition.
No other prayer.
Yes, my lord. Because virus has been challenged, consequently it is prayed that they should be given promotion from out of that list.
Oh, that is different. There is no prayer for recall of that order.
Yes, ma'am. Now, my lord, as far as this writ petition is concerned, that is my submission, my lord, that the very assertion that they were necessary party to be heard, my humble submission to this honorable court will be no, my lord. They were neither necessary party nor proper parties.
Yes.
They were only being beneficiary of an order of the tribunal.
They were going to be the beneficiaries.
Going to be the beneficiary, and without being party there, and that order of the tribunal in its proper following the due procedure, maintaining the opposite parties who were added there, having been adjudicated by this honorable court, and then having, no doubt, my lord, by SLP dismissal on the first day, but having been adjudicated by this honorable court, and then the Supreme Court stands confirmed, and should not be recalled, man.
That is my submission.
Yes.
Only one line.
Oh, you will have to know online. You will have to
Sir.
respond.
Sir,
And he appears to be correct in his submission that you are not necessary parties.
sir, that is exactly my point.
Yes.
That is exactly my point. If I have correctly understood, only the contention with regard to necessary party or not. I will not go further. So far, the contention raised by the petitioner in the writ application where order has been found and sought to be recalled, the contention was that the merit list or that gradation list is valid till it is exhausted. That is the contention. Also look again to paragraph 4. They cannot go back from that. Paragraph 4, that with regard to the contention that we are not necessary party, I am addressing Lords. Let's come to page 48 again. Page 48 again. My learned friend's argument is I am the beneficiary of the judgment passed by the tribunal, so I may be affected subsequently. That's another part. But so far, the select list or gradation list, what their contention before these division bench, which is sought to be reviewed, let's look to that.
No, but there were persons in at least in representative capacity.
Sir, there are not one person who had filed an application for intervention.
Yes.
But what I want to say,
Not only intervention, these OA applicants, they were also there.
sir, the applicants, those who are applicants, they had challenged the subsequent advertisement which was made by. You also look to that.
No, but they were parties in the writ proceeding.
They were parties, but so far as
So they were representing your case.
My entire submission is not that, Lord. Whether a person whose names find place in the select list or gradation list on the basis of which they have given appointment to 107 or on 18, whether they are necessary parties or not, let's look to our judgment. Which judgment has been followed. I think my Lord Justice Raman was also party to that. That ASO case. A person who was relying upon this judgment, of course, that is a very big judgment. I have not brought, but this judgment which I relied upon, I have done. Whether my names find place in the select list or gradation list, and I am being whether affected or not, whether I am necessary party or not, you also look to one paragraph only. Paragraph 30. Yes. We'll also kindly come to paragraph 30, just above 31.
Yes.
Yes.
You mark a tick.
Yes, yes.
In the present case.
In the present case, successful candidates were not made parties before the learned tribunal. Mr. Das, learned counsel for the opposite party number 12.
Oh, from there.
Sorry.
In the present case.
In the present case, successful candidates were not made parties before the learned tribunal. Mr. Das, learned counsel for the opposite party number 12 to 22 in his submission made it clear that they had been made parties. They would have surely raised these issues and would have drawn the attention of the learned tribunal to the decision of so-and-so versus Supra. Further, there is no reference to Dr. So-and-so case in third three-bench judgment decision in so-and-so case. Thirdly, from the facts of the said judgment, it is not clear as to whether, like the present case, where the Honorable Chairman has assigned the recruitment matter to a division bench, whether the said case was any such notification was taking a promotion matter by a division bench. Further, as has been submitted by Mr. Das, had this client been made parties, he would have raised that issue before the learned tribunal. Simply because the petitioner had not raised the issue, would not go against his client as the right of opposite party number 12 to 22 protect and defend the select list from which their right to sit in the main examination floor have been taken away behind their back. Section 5(6) of the Administrative Tribunal Act 1985 provides that a single bench can only take up such matters which have been assigned by the Honorable Chairman. Here, as indicated earlier, the matter relating to recruitment was never assigned to the single bench by the Honorable Chairman. For all the reasons, we have no hesitation to hold that the order passed by the single bench is wholly without jurisdiction. The decision cited by the opposite party number 1 reported in so-and-so cases, so-and-so, in so-and-so, since there is only one member, that is a vice chairman for the entire tribunal, the High Court observed that the matter can be heard by one single bench, though the matter should have gone before a division bench because as per the settled law, the tribunal is the court of first instance on the ground of doctrine of necessity. Here it is nobody's case that on the date of disposal of the Odisha Administrative Tribunal, parties directly approached the High Court, and accordingly, the High Court directed to approach the tribunal in the past. In so and so, there is no reference of Dr. Mohit Lal case. Further, here the point relating to hearing the division bench. But sorry, Milord, I must, my learned friends,
It is there.
it is there, but the exactly point is that has been dealt to it.
No, that point is there.
Yes, I think there is no reference to so and so. Further, here the point relating to hearing by a division bench has been raised by a successful candidate who had deliberately not made parties before the tribunal. Moreover, there is clear-cut notification to refer the matter to a division bench there. For all these reasons, we hold that the land single judge had no jurisdiction to hear and dispose of the original application. But it is, but this judgment will not, paragraph say that is not the exact paragraph. I have read it again and separate.
Recent case also. Under the Supreme Court has laid down the same principle that people, number of candidates are there. And representative purposes pick up some candidates and complete them as partial. Not at all in the picture.
Remember, judgment and hard to there.
See, writ petition which was filed here was against an order of the tribunal.
Right, sir.
It was not, you can say, original application.
No.
Under Article
No.
227.
The writ application.
226.
Right.
226. Rather, this application, the application was filed because of the Supreme Court's decision.
Yes, sir. That L. Chandra Kumar case.
L. Chandra Kumar. So it is not that because the petitioners here in the High Court were challenging the order of the tribunal.
Right, sir.
Because of the judgment laid down by L. Chandra Kumar. So therefore, they were not required to implead all persons beyond the persons who were arraigned in the...
Sir, because of the judgment of the tribunal, so far now the question is with regard to the validity of that select list or gradation list. So the validity of the gradation list, the subject matters. The division bench of this honorable court, this might have been challenged under Article 227 because of the L. Chandra Kumar case, but the adjudication which is
227, Article 226,
maybe,
227,
yes,
both.
So both that can be both also. So the adjudication sought to be made by the division bench of this honorable court is as to whether the validity of that select list, in case the contention raised by the state in the very case is accepted.
In no case, the writ petitioners of that case can be blamed for not impleading you as parties.
That is one million. But second is a person who is being affected by the judgment.
So many persons can be.
So many, no, sir. So total 31 person who have already got the promotion in the meantime. That is what the now the question is whether my position in the validity list and that select list maybe after expiry of 3 years, whether a certain right is created in their favor or not, whether they are necessary parties or not.
In fact, when a law is laid down,
that is what exactly.
There can be so many persons.
So that also your worship has said, that your worship have said that the person, those who are affected, even if they have been selected for in the test.
We agree to that.
That's it, right. So in that case, at least some opportunity must be given. Now you also see the validity list. Now it was held to be invalid after expiring 3 years, and a direction has been given, no promotion. But the interpretation what the state has made and state the entire case was that we have given rightly to 107%. There is no such provision except 660, and they have accepted.
And what about that decision of the division bench? This short order passed by the division bench of this court.
So the short order is that is only because the writ application was filed in 2021 after 4 years that has been dismissed. That cannot be
one of the ground.
So that this is the case where it has been filed immediately.
But observation is made that subsequent in a subsequent writ petition, because can we sit over the order of another writ court?
No, that is exactly, yes, sir. That is exactly. In this case, I have prayed for a review of the application because in view of the judgment and the policing case.
All
Re-
we will see.
And throughout the state's case is that till it is exhausted, that that is their case. In this particular case, which now the judgment has been passed. Till it is exhausted, paragraph 4.
Please do that. Whatever you say, we will read. Whatever you mention in your written notes of argument, we will see.
The previous division bench said, made it open to the party to approach. That liberty was available in the previous division bench, which dismissed the writ petition. Leave was granted. You can go to the other, means a review petition. By way of a writ petition, a review has come. So, liberty was para 3, liberty was available. Your lordship have granted.
The writ petition was dismissed with a liberty to file review.
This is by way of a review. My application is by way of a review. That was the writ application where it was challenged. That cannot be.
So similar fashion, today also we can do that.
I will not do that.
Because of
the substance of the substantial justice here is person 107, they got the promotion. 18, they got the promotion. We got the promotion. We adjusted the training, but we have been deprived. That is the whole thing.
Yes.
Because of the one line there that they will not get, henceforth not get. While passing that order, we are not before your loss.
Already is.
My lord, it is misplaced, my lord. Once they have got some sympathy, and we are the person about
15,000,
15,000, my lord.
See,
we are not appearing in any
Counsel, we are not governed by any sense of sympathy or anything. We are governed by law. That's all.
Item number 56.
Yeah. So we can take up at 4.
Here, I take models to the manufacturer.
Oh, sorry. That is exactly what Supreme Court follows.
No. You also used to follow.
Well, you will follow.
As I submit my notes to the regarding the legality or propriety of the judgment of this honorable court. In short, my lord, the fact is recruitment to the post of music teacher is the subject matter of consideration before this honorable court. Now, in short, if I put facts like this, my lord, an advertisement was published. One of the posts for different posts, one of the posts of those posts was also a music teacher for which a qualification was prescribed. Now, our case is that the petitioner doesn't have the qualification. That is the state's case, madam. And giving a false declaration, because all these applications were online, giving a false declaration online that they possess the qualification, their applications were received. They were not only received, they were provisionally selected and they were appointed. Now, one consequent upon filing of a OA before the tribunal, the department had the occasion to look at and scrutinize those appointments, because those appointments were challenged. While scrutinizing those appointments, the authority found that the writ petitions were not having the requisite qualification in accordance with advertisement. Then we called them for verification. They came, submitted their originals, and we, by a reasoned order, we terminated their service. That termination order came to be challenged before this honorable court by the petitioners here. That decision is under, now is a subject matter of adjudication before this honorable court. Now, before my lord, I must take my lord's first.
So how did you proceed after you learned that he or she did not have the qualification? How did you proceed thereafter?
My lord, we called them, gave a notice.
Notice what?
Please come and submit your, it is alleged that you don't have the requisite qualification.
Then
please come and submit the original of your certificate.
Then
they came, they submitted, and by reason order we said
there is no question of reason order. You were required to issue so cause.
No.
Did you do that?
I didn't, while saying the short facts, I didn't say that, my lord, because we have not done it. So, but my lord, question is, here why I am aggrieved, ma'am.
Is it a government service?
Music teacher.
Then 311 will apply.
My lord, even then, I would not have been aggrieved, ma'am. But this honorable court has held that the qualification held by the petitioner is inconsonant, is valid qualification. That's where I am aggrieved, ma'am. True it is, my lord. My lord posed me that question. What I did, if there was an error, or there was some irregularity in the procedure, my lord, I could have reverted back to that position. But I had all the right to say that yes, this qualification is not in consonance with the advertisement. And that, my lord, may kindly see. I will take my lord first to the very advertisement. May I take my lord to page 158, where I have given the complete advertisement.
Annexure?
This is my lord. Annexure
2? No.
This is my lord. Actually, this is part of my, because I have annexed the counter, writ petition, counter, agenda, everything.
Page 40. Page 40.
My lord,
advertisement number 1 of 2015.
150.
My lord.
I got.
Running page
I got it.
157.
Yes.
After writ appeal, I will not take my notes anywhere else, because
Yes,
all
sir.
the documents I have annexed here.
Yes. Yes.
Now, the relevant provision, my lord, is 158. At page 158, my lord, may kindly see clause 3.
Yes.
May I read it, my lord?
Please. Clause 3.
Clause 3. My lord is looking at page 158.
158.
157.
158, ma'am.
158. E by 2. Annexure E by 2.
My lord.
158.
This is the advertisement, ma'am.
Yes, yes.
Ma'am.
Important instructions.
Ma'am.
Yes.
Because I will take my lords to these instructions, because these have been relied upon by this honorable, by the honorable single judge.
Yes. Come to 2. 2 is the qualification.
In order to be eligible for appointment, a candidate must satisfy the following conditions: must be a citizen of India, must be of sound mind, must not be having more than one spouse living. Then 3, candidates having master's degree / bachelor degree in arts / commerce, science with bachelor degree in education from any university of the state. Then number 4, regarding universities / institutions of outside state, the candidates shall only be eligible for appointment after verification of genuineness of their educational training qualification from concerned university / institution from which they have obtained the degree. Such outside university / institution candidates shall have to produce the authenticated proof of equivalency and NCT recognition in support of their qualification at the time of verification, failing which they will not be eligible in the selection process. Well, these are all, this advertisement is admittedly not under challenge. Then my lord may kindly turn to page 163. my lord will find music teacher in the table below. Music teacher, my lord will find.
Yes.
My lord may kindly see the qualification. Senior secondary school certificate or intermediate and bachelor degree in music from a recognized university. My lord may kindly, I put emphasis on this now. This is the advertisement. May I read it again, my lord?
Yes, you've seen.
Bachelor degree in music from a recognized university. This is what we want. Then competence to teach through English Odia medium. The knowledge of computer application desirable. We are not concerned.
Yes.
My lord, I will take my lord kindly to page 177.
Yes.
My lord, I'll take my lords to that A, B, C, D, E, F, G, H, I, J, J.
Yes.
Possessing any form of textual material or handwritten, this is not required, but because I'm to read it, so I'm reading it, my lord. Pages, etc. In addition to rendering.
Caption at any stage of recruitment or later.
My lord.
If a candidate is or has been found guilty of any misconduct such as
F.
That is the heading.
NG.
My lord. That is the heading I am reading, my lord. I am reading J. Possessing any form of textual, material, handwritten or typed pages, etc. My lord.
No, you're not reading J. You are reading J. You
Yes.
should read F, G.
26 to J.
J.
My lord. 26 Roman to J.
Yes.
H, I, J. A, B, C, D, E, F, G, H, I, J. Just above 27, ma'am.
Yes.
Possessing any form of textual material, handwritten or typed pages, etc., in addition to rendering himself, herself liable to legal criminal prosecution, will also become liable to be disqualified from the examination and or debarred either permanently or for a specified period from any examination, recruitment and or discharged, removed, dismissed from service if the act of misconduct comes to notice after his or her appointment to the service of OAV. That is Orissa August Vidyalaya. So, my lord, I am just reading because, my lord, I will have the reference of this clause subsequently at the time of my submission. At this juncture, may I take, my lord, to petitioner's qualification. What is petitioner's qualification, my lord? My lord, may kindly see. It is the own admission of the petitioners that at page 31, may I take, my lord, to page 31 now of the writ appeal. This is the writ petition I have annexed. So, in the writ petition, in paragraph 2, what the petitioner says, man. Page 31. My lord, sir, page 31.
Yes.
My lord, I will read from the last line from page 30. After successful completion of interview cum skill test, the petitioners were appointed as music teacher in different model schools by order dated 11/4/16. It is pertinent to mention here in this context that the petitioners have passed the intermediate and purchased the bachelor degree in music / Sangeet Visharad from Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay. So the petitioner is an intermediate and she has got Sangeet Visharad from Akhil Bharatiya Gandharva Mahavidyalaya Mandal. This is the qualification. I have taken my notes to the qualification I have in the advertisement. Now, one may kindly see, with this background, she was given appointment. She was found suitable in the recruitment. She was found suitable. She was given appointment. Then, because of a OA file against this petitioner, we had to scrutinize those, and we found that this Sangeet Hisara from Akhila Bharatiya Gandharva Mahavidyalaya Mandal is not a graduate degree at all. Number one. Number two, it is not equivalent to graduate degree. Number three, it is not from a university. These are the three things.
So there lies two things. One, degree from recognized university. So is it your argument that this Gandharva Mahavidyalaya Mandal, Bombay,
It's not an university.
not recognized?
Not an university, man. Or less to speak of recognize. It's not, this is admitted by the petitioner. This is admitted.
No, we don't dispute that.
So, so these are the three things on which, my lord, our termination of the petitioner was made. Because you are not qualified in accordance with the advertisement. Now, my lord, may kindly see. I'll take my lord through that termination letter for a moment. My lord, may kindly see page 72.
No, but where is the finding and on what basis? By the single judge?
Yes, ma'am. I will take my lord to the judgment. Before that, I just wanted to take my lord to the order of termination so that my lord should have my stand very clear. May I take my lord to page 72? My lord, sir, page 70.
Yes.
Now, the prescribed, my lord, I'll be reading only relevant. I will not read the entire order, my lord. Second paragraph. The prescribed qualification for the post of music teacher was as follows in the advertisement: senior secondary school certificate or intermediate or bachelor degree in music from a recognized university, competence to teach through English ODI medium, desirable knowledge of computer application. On verification, my lord, I'm reading the last paragraph. On verification of his certificate, it is ascertained that Sri Nayak has passed higher secondary exam in arts from CHSC and diploma in Sangeet Visarat from Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay. The applicant produced a copy of letter number 48695/2001 dated 31/8/2001 of Utkal University, Bani Bihar, Bhubaneswar, wherein it is informed that M Music degree and diploma conducted by Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay has been recognized as equivalent with M Music and diploma of Utkal University. But there was no notification from any University of Odisha in support of equivalence of Sangeeta Visarat from Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay with the music degree of an University of Odisha, which the applicant did not disclose at the time of document verification. Subsequently, it came to the notice that Utkal University of Culture, Bhubaneswar, by letter number 22327 dated 23/6/2015 has clarified that the degrees awarded by universities, institutes which are not recognized by the UGC as per section 2F of the UGC Act 1956 are not considered equivalent to graduate degree awarded by the university. Accordingly, the degrees awarded by Prachina Kala Kendra, Chandigarh, Akhila Bharatiya Gandharva Mahavidyalaya and Bangla Sangeeta Parishad are not recognized by Utkal University of Culture. Then, my lord, we have said as well, because you do not possess the qualification, we have come in. May I take my lord to the judgment? I will first take my lord to paragraph 44 at page
44 of what?
44 of the judgment, my lord. I will, because my lords have narrated the facts of the case.
I got it. Yeah, university. It's a question of whether it is a university or not, recognized in accordance with law or not. That is the only question.
I couldn't understand.
See, according to you, the Utkal University says that that degree does not have any equivalence. All right.
No.
It is your case that it is not a university at all.
Yes,
What to talk of recognized university? This is your submission.
That is one. Number two is he doesn't have the even qualification. B music he doesn't have. She has M music degree.
Higher,
What we require?
higher qualification. She has higher qualification.
No, that was not the requirement of the advertisement. Alva, kindly visualize the situation. Advertisement is not.
Yes, let us see.
No. Paragraph 44. May I take, that is at page 220 of the written.
220.
No.
Yes.
As has been stated here in above, the petitioner have obtained the qualification and certificate of Sangeet Visarad from outside state institution like Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay or Prachina Kala Kendra, Chandigarh, which are admittedly institutions imparting course of music and well established in the national level. Further, going through the materials placed before this court and submissions made the counsels appearing for the petitioner in the batch of writ petitions, the court observed the above noted institutions are very old music institutions of the country and the same has produced many legends in the field of music in the country. No doubt, the above noted two institutions have not been declared as university under section 2F of the UGC Act. Therefore, they are to be treated as outside institutions for the purpose of advertisement, and accordingly, the validity of the certificates issued by such institutions are to be decided by applying the test prescribed in clause 3(4) of the advertisement. This court also observed that the opposite parties have not disputed the genuineness of the certificates issued by the above noted two institutions. However, on an additional government advocate raised objection with regard to declaration of equivalence and submitted that equivalence is required to be mandatorily proved by the petitioner by producing authentic proof. Paragraph 45, ma'am. So far, equivalence is concerned. This court is conscious of the legal position, and it is the settled position of law. The declaration, consideration of equivalence is a subject matter that doesn't come within the domain purview of a court of law or any other authorities. Rather, the same comes within the exclusive domain of the authorities, expert bodies who have been conferred with such power to consider and declare such equivalence. Mostly, it is the expert body of the universities concerned which are competent to decide the equivalence of any course, degree, and the court should ordinarily refrain from interfering in such actions and not to substitute its views, replacing the view, opinion given by such expert bodies with regard to equivalence. Having held so, my lord, may I take my lords to paragraph at page 215. I will not read the entire judgment, my lord. It's, my lords have, because the facts of the petitioners and the respondents and the opposite parties have been narrated in detail. May I take my lord to page 215?
Yes.
My lord, para 38 I am reading. Having heard learned counsels appearing for the respective parties on a careful consideration of the contentions raised by the learned counsels, on careful scrutiny of the pleadings as well as materials placed before this court is of the considered view that the most pertinent question which is required to be decided in the present writ application is as to whether the qualification of Sangeet Visarad conferred by Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay in the year 2006 to 12, respectively issued in favor of the petitioners number 1 and 2 is a genuine certificate. Secondly, as to whether the qualification of Sangeet Visarad is equivalent to B music degree. This is important, my lord. I lay emphasis on this one. Sangeet Visarad is equivalent to B music degree granted by outside institution, university, and whether the documents produced by the petitioners to prove the equivalence is an authenticate one or not. In other words, the dispute involved in the present batch of writ applications revolves around the certificate issued by the Akhila Bharatiya Gandharva Mahavidyalaya Mandal, Bombay, and Prachina Kala Kendra Chandigarh in favor of the petitioner in the above noted batch of writ applications are genuine or not, and whether the equivalency declared by a recognized university of the state and the letters issued by such university of the state deciding equivalence is valid in law. Para 39, ma'am. Before making any attempt to answer the aforesaid questions formulated by this court and before adjudicating the issue involved in the presented applications, this court at the outset would like to refer to clause 4 of the advertisement number 1 of 2015 under annexure 1. Clause 3 of the advertisement provides important instructions, and under subclause 4, the procedure with regard to certificates issued by the outside state university institutions have been laid down. For better understanding the provisions of clause 3.4 of the advertisement that has been quoted, my lord, then para 40. On a careful analysis of the aforesaid subclause 4 of clause 3, this court observes, with regard to university institutions of outside state, the candidates who have obtained such certificates shall only be eligible for appointment after verification of qualification from such university institutions. Moreover, candidates who have undergone the course in such outside institution universities and relying upon such certificate for appointment shall have to produce authenticated proof of equivalency in support of their qualification at the time of verification, failing which such candidates will not be eligible in the selection process. In para 41. In the instant case, the facts pleaded by the petitions and the certificate produced at the time of submission of online applications are to be tested with touchstone of clause 3.4 of the advertisement. Therefore, by applying the yardstick of the clause 3.4 of the advertisement to the facts of the present case, this court observes that the opposite parties, having not disputed the genuineness of the education, training qualification, or even genuineness of the certificate produced by the petitioner as Sangeet Bisarad, in such view of the matter, this court has no hesitation to hold that the certificates produced by the petitioner from Akhila Bharatiya Gandharva Mahavidyalaya Mandal Bombay as well as Prachina Kala Kendra Chandigarh are genuine certificates issued by such outside state institutions. It is apt to mention here that the petitioners also admit the fact that the aforesaid two institutions are not recognized university under section 2F of the UGC Act. Therefore, the same are to be treated as outside state institutions. Since the qualification obtained from the outside institutions are also.
Let us see the advertisement again.
No. That is at page 157. Of course, that is also. Before that also, Mano will find it. 157. The relevant is, my lord, clause 3.4 at base 158. Shall I read it then?
Just a minute. Oh, that is not the qualification. Qualification is somewhere else.
Qualification is at page 163, ma'am. That's what I was trying to show. 163.
Yes, this is the qualification.
Yes, ma'am.
Music teacher.
Yes, ma'am. And in very
Just a minute.
no uncertain terms.
Just a minute.
I'm sorry.
From a recognized university. That is the only thing.
Yes.
All right, we'll see. So this is an admitted fact. There is not a university and there is no question of recognition.
Yes.
All right. We will hear tomorrow.
I will hear it at 2 p.m.
Tomorrow, normal. Because most of the, in fact, this is an admitted fact.
I will take another.
I'll satisfy your lordship.
All
I'm
right.
satisfied.
All right.
My lord,
I will maximum another.
UGC has not declared his university, but certified. Those institutions are authorized to issue certificates of their course.
That is not the question. question is whether this institution is a university or not.
In terms of clause 4.3, my lord.
We don't know anything.
Right,
The word which has been used in the advertisement is university. You will have to demonstrate that the place where you studied is a university. It's a simple question.
Well, 4.3.
Pardon, my lord, pardon.
1 second, ma'am.
4.3 we will
Item
not
50.
see. We will confine to this 3.
No,
We will not
My
go
lord,
to 4.
item-
We will not go to 4. We will go
My lord,
to
pardon-
this 3
pardon me to
essential.
mention.
This is essential.
Well,
This is fundamental.
Yes, ma'am.
So
And I
we
am
will
having
not
that
go to 4.
I am having that qualification.
If you have qualification from any university, it's good.
My lord, pardon, item number 50, my lord.
Item 54, let it come tomorrow or a similar matter will also dispose of.
Similar matter.
No. My lord, item number
Yes,
50.
Item 54.
All right, 54.
My lord, item 50. My lord, item 50. My lord, pardon, item 50, yesterday, my lord, have directed us, if matter is not reached, then mention. So it is not reached, my lord. Maybe top of list as direction directed by your my lordship.
So tomorrow in the first half, you just remind us.
My lord.
It is to be taken up. All right.
My lord, item 51.
Yes.
My lord, 65 tomorrow, my lord.
All the leftover.
My lord, I don't know. My lord, item number 57 next week.
My lord, item 61, I have some difficulty tomorrow, so let it be some.
Ask someone to be here. We will accommodate.
Item number 57 next week.
Please come.